in the courthouse where time stood still. Generations pass on the hill, prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her tonight. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption's grip tight as a vice. In this endless trial, we pay the price.
Hello, folks. Trial day 90. Day 765 since Jeffrey Williams was put in jail. And day 2 of Attorney Steele being found in contempt and will be forced to serve 10 weekends in jail, in the same cell as Mr. Williams. That is where we are. Now, yesterday, I was spent. And of course, minutes after I went off stream, things happened. Of course, because Murphy's Law. But that gives us something to talk about up until, well, we will do recap what happened yesterday. Now, Woody's actual him testifying is no longer really interesting. We are all waiting for cross-examination, aren't we? Oh, yeah, we are. Oh, yeah, we are. So we have recap from yesterday. Then I have the emergency motion for supersedes bond on criminal contempt to read for you. So we have plenty to do before today's trial starts, and we will catch up anyway. Because why? Judge Glanville is always late. We already know that, all of us. And he will take comfort breaks. And there will be, skipping ahead and stuff. No, Kirsten, didn't prosecutor state they expect the director last rest of week? Well, we'll see. We'll see. I mean, of course, they want it to last as long as possible, but they can't ask him stupid questions indefinitely. They simply can't. They can try, but sooner or later, Ron Barnes asks, how does a judge mix up contempt charge? Because nobody has probably called him out for it. This is, in my opinion, so I don't get into trouble. In my opinion, Judge Glanville sees himself in very high regard. And simply cannot be wrong in his own mind. So he was so surprised by being called out on Monday. Because I'm betting he was so certain of this. But they showed him, you're an ass. You're wrong. Excommer Z. Thank you for Norwegian's krona. Last nick of YouTube. Yes! The only Coke you will see on my stream is cola. Do we have the same bull crap here in the north? Not to this level. Nowhere near this level. Right not to speak, but the state can force you with immunity. No, we don't have immunity at all. You can't offer immunity. It's called, in other words, a crown witness. Now, there are suggestions of legislation which will be turned down because it pops up every few years. But no, and you cannot. We have this. You can actually somewhat force a witness to testify, and we also have a very much stronger legislation regarding when witnesses lie. Just the other day, in a trial where people were sent to prison for a very long time, one witness changed their story on the stand, and they are now facing charges because of that, actual charges. And cops have been charged with this, even cops here. So we take lying in court a bit more serious, I think. And now let's see where it is, because I'm trying to do something. So let's see if this works. Hey! I haven't gotten those two put together yet. Oh, here we go again. Oh, what? No, don't loop track. Yeah, me saying thank you for your super chats and everything. Yeah, but I want to do more. Here's the thing. That is yeah. I press on an overlay and then I press on the sharing. Hey. But thank you, X-Comers. Thank you so much. No Kurasan. Isn't the protection during interrogation in the North worse? Yes, it is. You can ask for lawyer and the cops can't just keep on questioning you. There are no Miranda rights. There are no Miranda rights. You are being told your rights, but it's still not the same. Now, it's weaker in that sense that they can keep questioning you, but you will get a lawyer appointed, at least here in Sweden, if you are charged criminally. So you will always have the option, because we don't have this pay-to-play here in Sweden. You get a court-appointed lawyer. That's it. Yeah, if you're being charged. You can have a lawyer if you are interrogated. As a witness, I mean, that you can do. You can have your own private lawyer. But as soon as you are charged, well, not charged, as soon as they have a level of suspicion enough to bring you in for questioning, you have the right to an appointed lawyer. But they can still keep questioning you until the lawyer gets there, more or less. That is the very comprised? No. That's the short version of it. All right, but we need to listen to what happened yesterday. And so let's start today with the compressed. Thank you, No Kurasan. Okay, let's listen to what happened after I went to bed.
Can we bring Mr. Copeland back? And first, is everybody back? I'm sorry.
Yes. Yes.
Mr. Steele's not back.
Good morning. Good morning. Good morning. Good morning. Yeah. Free balls Steele. Hello, Gwendolyn. Sydney. Reform convict. Kimberly.
I'm waiting on Brian Steele first.
Becky. Hellraising Angel.
No, Brian
and everybody
Steele.
else.
He's walking in the door now.
Okay. All right. Sergeant Ingram, are all our participants back, sir?
Yes, sir. Everybody.
Okay, councilors, if I get you to take your seats and gather your thoughts, please. Okay, before we call in our jury, it has been brought to the court's attention that Mr. Copeland's counsel, Ms. Bumpus, would like to be released. Is that correct, madam?
Yeah, she wants to be released, but not released at that. She had a limited purpose. She went there because his actual lawyer asked her to be there for the limited purpose of the contempt. That's it.
Okay, all right. Sir, Mr. Copeland, is it your desire to release your counsel at this point in time?
She fired.
She's fired? Okay. So do you wish to represent yourself in these particular, in terms of any issues you may have in this particular?
Yep. He fired her on the spot. Yep.
Do I got a choice?
I'm sorry?
Do I got a choice?
Yes, you do.
And what are those?
You can keep your lawyer that you have right
I don't
now.
want her.
All right. You could certainly hire another lawyer, or the court could appoint you a lawyer.
What I need a lawyer for?
Hmm?
What
No, it's just the court is just asking you whether it's your choice, sir.
I'm good.
You're good?
Yeah.
Ms. Bumpus, did you file an entry of appearance? All right. Did you, under the Uniform Superior Court rules, file a motion to withdraw pursuant to the Uniform Superior Court rules? I mean, I know you give an oral notice, but usually it has to be in writing, and he has 10 days to object.
Just for the record, I forgot his counsel.
Say again?
I was never his counsel. Attorney Dunn was his counsel, and I was stepping in as a courtesy for judicial efficiency. But if the court's desire for me to file a motion to withdraw.
Yeah. Here's the thing. Judge knew this. Because Friday, when Woody's actual lawyer, he said, I will get somebody there for the purpose of the contempt. Because he couldn't be here, because he had to travel. And apparently, he asked her, can you please step in for this guy? He's being held in contempt. And she was thrown right into this fuster clock. And I don't think she will be doing his lawyer, who I forget the name of, I don't think she will be doing him any favors anytime soon. But I blame more the judge, because judge screwed up royally.
Well, given the fact that you have represented Mr. Copeland at this point in time, it would seem appropriate that you do need to, in fact, file a formal withdrawal. Even though you didn't enter one, you de facto entered this case by your representation of him, or you telling the court that you did, in fact, represent him. So at this point, I'm not inclined to release you until that's done.
I'll get that done now, Judge.
Okay, all right. And he's got 10 days to go ahead and do that. So you're still going to have to be here until I have because he gets that particular period of time to go ahead and decide whether or not he'd like to hire a lawyer. That's the whole reason for the 10 days.
Well, I don't want to hire no.
Hold on. Not yet. You get that right as a party. Okay.
This is what I don't understand. And here's the thing. The judge knows Mr. Copeland has a lawyer. She's just a stand-in. He knew. But he doesn't care because, yeah.
Okay.
Right?
You do. Yes. You get that right to hire a new lawyer. You get the right to do a couple of things. One, to decide whether or not you can release her.
Okay.
Okay. Two, you get to decide whether or not you want to get another lawyer to be with you.
Okay.
Okay. Those are the two big things you get a chance to.
And here's the thing. Judge Glanville, you know Copeland has a lawyer. You know. He was there Friday. So he doesn't need to hire a new lawyer. He needs his original lawyer there.
Kind of decide. But what I'm going to do at this point in time is, since she's representing you, I'm going to make her file a formal notice to withdraw. She's orally told you at this point in time she wants to withdraw, but you're on the stand. You're testifying at this point in time. So I'm not going to let her withdraw at this point.
Well, Your Honor, I just would like to say, before he started testifying, I was fired.
I don't know that, ma'am. That's not something that I have notice or knowledge of. So, that's the whole purpose of the rule, so that we can flesh out all those things. So at this point in time, I'm not inclined to let you go at this point. I'm sorry that you put yourself in this particular situation when you and Mr. Melnick and whatever, but, Mr. Copeland does have rights in this particular circumstance. So file a proper notice to withdraw. I'll give once it's filed, if you file it today, I'll give Mr. Copeland the 10 days, but until such time as I rule upon that and he gets that and gets an opportunity to think about what he'd like to do, I'll go ahead and insist that you remain with us while he's on the stand.
Okay, Judge.
Okay. Madam, I have one other bit of business.
Also, can I approach, Your Honor, with the state?
No. What does he want to tell me?
I don't want to say it in open court.
All right, State, Ms. Bumpus, come on up. And I don't believe you have the right to be present, sir.
Again, Judge, they do have the right to be present because this is a part of the fucking trial. This is infuriating. Completely uncalled for. So now Mr. Copeland's fired lawyer can be there. The prosecution can be there, but he denies the defense access to whatever information this is.
State objection to the record. I do think we have right to be present, and I think there's case law to that effect. I want to object on the grounds that we are now being excluded from a conversation about material witness in prosecution state versus non-dependent and material witness, conversation about material witness, and a conversation between the court and that counsel for that witness and the state, which are now conducting a meeting with the court without the ability for me as the attorney for the defense in our case to be present and knowledgeable about those conversations. And I think that that ex parte communication creates an appearance.
Sorry, I was typing.
I see this with tremendous reservation, and I also want to apologize for saying it. I think it creates appearance of impropriety and bias on the part of the court. I don't mean to suggest Your Honor is doing that, but it creates the appearance of it. So I have to check.
Okay. Your Honor, I'd like to just add, I'll adopt everything that's said, but I'd like to just add also under Article 1, Section Paragraph 12 for the Constitution, it also denies Mr. Williams his right to a critical stage of the proceeding.
And sorry, Your Honor, if I could just add to that for the record. I'm going to cite to the Uniform Security Protocol 4.1, which prohibits this type of communication. I'll cite to the Georgia Code of Judicial Conduct, Rule 3.4, which prohibits this type of communication. And I'll cite to the court several cases which I think support that. The first is Monday versus Magnolia Advanced Materials, which is 815 Southeast 2nd 70. It's Georgia Supreme Court from 2018. I'm going to cite to the court. Wynn versus State, which is 139 Georgia Act 355, 1976 case. Trial judge should not attempt to sit witnesses testify on behalf of the state either in or out of the presence of the jury. And it also creates a presumption that the court should have to recuse itself. In that case is Purvis versus State, and that's 319 Georgia Act 432. That's the Georgia Court of Appeals case in 2012. I think
Okay.
And they keep citing case law to tell the judge, you are way out of line and you should step down. But he won't. We already know that. But they have to have it in the record for appellate issues.
Your Honor, I just wanted to be given an opportunity to be able to respond to that on the record and to point out that the distinction between the assertions by counsel for the defendants and what is going on here, and the assertion being made that a trial judge should not intimidate or coerce a witness. Actually, can we?
Yeah, hold on a second. Mr. Can I get you to step outside for just a second? Let me finish this argument, please, sir. Mr. Copeland?
Where, you want me to go out?
Yeah, just step outside in the vestibule if you wouldn't mind, sir, please. Thank you.
Yeah. And now they will lie. I assume Miss Love is lying because her lips are moving. And they can assert anything because they refuse to release the transcript. So they can say anything, and no, they can't be called out on it until a higher court forces them.
All right, Ms. Copeland's left us.
Your Honor, what I believe that Ms. Bumpus wants to address with the court is strictly and solely the civil matter that involves the motion of the state to compel her client, Mr. Copeland, to testify, the offer from the state of immunity should Mr. Copeland testify, and the motion of the state to the court to sanction Mr. Copeland if he fails to comply with an order of the court pursuant to 24-5-507. That matter is a separate matter from the trial that is.
No, it is not. Do you know how I know that? Because he's testifying in this trial. It is that easy. Even though the claim is, oh, this is separate. No, it isn't, because you called him as a state witness in this trial. Without that subpoena, he wouldn't be here. That makes him a part of this trial. And that should force you and the judge to not only tell the defense you had an ex parte secret meeting, you should definitely share the information that was revealed in that meeting.
Going on now, it is akin to the state moving the court for a material witness warrant for a person who refuses to obey a properly served subpoena.
He is already sworn
It
in.
is not.
That only applies before that witness is in court. Before, not during.
Something to which either defendant is a party. And for that reason, it is our position that counsel for the defendants are simply wrong in this instance. And that if Ms. Bumpus chooses to address the court with the state regarding a matter to which the state as a moving party and her client as the person for which the state made that motion are involved only, then the parties to that matter are the state and Mr. Copeland. And so for that reason, I believe that Ms. Bumpus is entitled to address the court with the other party in that matter, which is the civil contempt order entered by the court on the motion of the state. at the time that the state moved the court to compel the testimony itself.
All right. I don't know what she's going to say. So that may make it not subject to ex parte or not. But what does he want to tell me, madam? Can you tell me the subject matter?
Yeah, about when he said he fired. And
Well, no, that we have to have a hearing on that issue. We have to have a hearing on that.
Okay.
We'll have to have a hearing
Oh,
on that
really?
issue. That's
Now you have to have a hearing on that. Now you have to. You don't. You certainly didn't want to have an actual hearing on the contempt. Oh no. Oh no. And you definitely didn't want a hearing about the ex parte meeting. No, 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 not necessary. But now, because they know the moment he says, "I plead the fifth," whatever circumstance, this trial is on stay until he gets an actual lawyer.
not an ex parte matter. Okay.
Well, what I'm trying to say is something that happened during the ex parte matter, which is why I don't want to say it in open court.
No, I'm good. Go ahead and reduce it to writing and your request to withdraw, and your client, which will bring back in, your client needs to be able to have a say so on whether or not you can withdraw, and he should get another. And if he wants to have you and wants to get another lawyer. So,
King Cooley, yeah, I said the same thing yesterday. If that info case is done, allegedly he confessed to Nutt's murder. Then, under his immunity, he walks. If there is no murder case, statutes of limitations on everything else applies. And statute of limitations have run out on definitely a majority of all the other underlying acts and overt acts. Definitely.
so that's it. No, I'm not gonna. It's not gonna be ex parte. Okay.
So,
Done?
As a result, Your Honor, if there's no
Hey, but you don't-
communication, and I'm withdrawing my objection.
Okay.
I just want to make that clear to the court.
That's fine.
The court doesn't.
No, that's fine. You're doing your job. No, you're doing. No, Mr. App, I wouldn't say that.
But I'm withdrawing the objection only with respect to this particular meeting.
Okay.
I reserve it with respect to any other.
All right. No problem. Okay. Can we bring Mr. Copeland back in, please? Can we hold off until Mr. Copeland comes back in? Okay. Nice.
Just to put the court on the record, it's my understanding from last week's proceedings that Mr. Copeland was actually represented by Mr. Jonathan Melnick, and that the court required Mr. Melnick to be here on Monday. And Mr. Melnick indicated that he had non-refundable airline tickets and that he would have someone appear in his place. So I believe Mr. Melnick is still this gentleman's attorney.
We don't know that. We really don't know. I don't even know if he's entered an appearance.
Screw you, George Glanville. You do know that. You know exactly what Mr. Melnick told you Friday. You know exactly what he told you. He is Mr. Copeland's attorney. You're saying we don't know that. Now Judge Glanville is lying to the court in open court. He's a liar. He has dug himself so deep into his little bunker of self-pity because he was called out on his absolute fustercluck behavior. So now he doesn't care anymore.
The circumstance thereof, but I'm dealing with it from the standpoint of Mr. Copeland is on the stand. He's a witness. He's had counsel. He's going to continue to have counsel. So that's the reason I'm stating this at this point in time. Okay, sir. But thank you for putting it on the record. Okay. All right. So Ms. Bumpus, file your motion. But until such time, you're going to need to remain as long as Mr. Copeland is a witness. And once we've had an opportunity to hear that, then I'll go ahead and do that. But it's not timely to begin with because he's on the stand. He's testifying. Okay. So whatever arrangement.
Oh, he's on the stand and testifying. We can't do this now. Well, apparently you don't care about those rules because you had an ex parte meeting where you coerced with the prosecution to get Mr. Copeland to keep testifying. Promised him as long as he is not a butthole on the stand, he can go home. And guess what? He got to go home yesterday. So he's no longer under contempt charges. They let him go home.
You had with Mr. Melnick. I'm sorry that that's put you cross purposes with not being able to be released. I don't know what difficulties it causes you otherwise, but I apologize on behalf of the court, on behalf of that. But
You're right. We did want to, the state wanted to put something on the record as well, that Mr. Copeland has satisfied at this point his contempt by testifying. So if he remains and testifies, then
How about that?
unless he wanted to, there would be no purpose for this. So long
How
as he remains
convenient.
and he testifies, that's the only if he pleads the fifth or fails to testify will he be subject to being placed in custody. So at this time, he has purged his or satisfied his contempt because he is testifying. So long as he remains in this posture, then we believe the contempt will be completed and he would not need an attorney. So, but I can't.
well, but that's his choice. That's what the rule gives him 10 days to do. We're kind of saying, well, make that choice right now. We're telling him here in open court to do that. So that's what the court's concern is at this point in time.
But Your Honor, I was representing him for the civil contempt, not as a witness. So that once he purged himself, I should have been released.
Exactly. Huh? Judge? Judge? You are so mentally down, Judge. You don't even know you're there, do you? What you gonna do, Judge? Dun dun dun! Come on, chop chop. Yeah. This judge, I've been saying for months that he is way over his head with this trial. And whatever happened the last week, he just crossed every boundary. And now he is not mentally capable to sit there as a judge. The higher court of Georgia needs to step in and get him out of there.
Have a seat, madam. I'll call you back. Okay. All right.
I'm sorry, Judge.
You can have a seat. I'll call you back on this.
Head.
Go ahead, man. You can take. All right, Ms. Bumpus. At this, go ahead, man. You can take the podium, please.
Pay attention, folks.
At this point, the court is still of the opinion that you need to file a motion to withdraw and give your client an opportunity to respond to that. So once you do that, and he has the opportunity to respond to it,
Judge,
I'll calendar it. In
will
fact,
you fuck twat? Oh, YouTube's. I said 4 quad. I really did. It's the accent. It makes my words sound differently when I speak them fast. I promise.
Unless he decides immediately that he wishes to not hold your or require your services, but usually
what?
he gets 10 days. So
And how would the court know if he's deciding immediately? Because
well, usually he's hearing. I mean, we have either the time passes and there's no objection is filed and you get it immediately. It's granted, or I set it for a hearing and he says, yes, I either don't want you as attorney or I want to have you as attorney. I'm going to get new counsel, or I've gotten new counsel.
And so Jonathan Melnick is just able to be released?
See, I don't know what the arrangement was between you and Mr. Melnick. I have no idea. That's not my purview. All I know is that Mr. Melnick.
He told you Friday, Judge Glanville. Mr. Melnick told you Friday he had to go on a trip, but he will send one in for the sole purpose of the contempt charge. So you know, when you claim you don't know, you're a liar.
Melnick was here on Friday. He said he was going on a vacation. I don't know if he even properly entered an appearance in this case. I know that.
Crap. Wrong button. Sorry.
Because he asserted himself as and represented to all concerned that.
Yeah. Here's the thing. Mr. Melnick never said he was going on a vacation. He never said that. He said he had unrefundable airline tickets. He might be off for surgery. Maybe his wife, kids, we don't know. So Mr. Glanville claiming vacation. This is how far gone Judge Glanville is. He's making claims he can't back up.
He was in fact Mr. Copeland's attorney. So, and then Mr. Melnick said that he would have counsel for Mr. Copeland on Monday, and that was you. And then you appeared on Monday. So I do think that you do need to properly withdraw and give your client an opportunity to do to have the full range of options. So until that's done, now Mr. Melnick may come back and may decide, well, yeah, I'm going to pick up, and I still represent Mr. Copeland, but I need to. I'll take up that issue when it was presented before me. Okay. All right. I'm going to set that, madam, for the morning of the 25th of June at 9 a.m. All right.
Because the judge
Let's summon our jury,
needs Mr. Copeland to have an attorney, because if he is going off rails again, then they have to coerce him back in again, and then he must have a lawyer.
Judge, may I speak?
Hold on, Sergeant Ingram. Did you want your lawyer's not in here?
She's not my lawyer.
Well, but you still have the opportunity to decide that. Okay.
He told
All
you
right.
now twice.
Your client wanted to say something, and he said, you're not my lawyer. But as I told him, I was about to tell him that he has the right to decide that issue, and he has to be given due process to decide that issue. So that's why I want that done in this case.
Is important.
Okay. All right. So at this point, anything else? As in respect to Ms. Bumpus?
You didn't give me time to say that.
Okay. I'm sorry. What else did you want to say?
Mr. Melnick told me that she was only going to be here for 1 day, and that she was going to make sure that after she's done, then it was going to be.
See, but I have no knowledge of those discussions, and because they asserted themselves as your lawyer, you have certain constitutional protections as being represented.
Now you're caring about constitutional protection. Welsh lady reads. Hello, good to see you. I hope that him trying to get rid of Bumpus doesn't mean his attorney Melnick is being released. He isn't. I have concern that he wants the withdrawal in writing so he can say Woody isn't represented by him. Yeah. Because Judge Glanville really didn't like Mr. Melnick. He really didn't like him. Because Mr. Melnick, he put up a fight. He didn't take BS from Judge Glanville. And when he comes back, everything that was said in that secret meeting, he will have the paperwork. He will have the transcript. They can't deny him that transcript. Oh, I can't wait for him to get back.
And by an attorney. I don't know what was said to you. I don't want to know what was said to you, but I'm just looking at who showed up and what they told us, meaning that me and the other parties here. So I don't know, and that's my kind of pause in this particular circumstance is that, and I need to find that out. So filing a withdrawal would help the court in this particular circumstance. Yes, Mr. App.
Just briefly, Your Honor, my obligation is always to help educate and inform the court. Uniform Superior Court rule does indicate that the 10-day requirement is made if the client consents to attorney withdrawal.
The 10-day only applies if the client wants to. It's not a requirement. Whoopsie. Did you misinform the court again, Judge Glanville? Did you make a false statement to the court on the record again, Judge Glanville?
I tell you what, Mr. Copeland, I'm going to send our jury to lunch. I'm going to let you talk with Ms. Bumpus afterwards, okay?
All right.
And then during the lunchtime hour, and then you can, hold on, wait a second. And then after that time, I'll go ahead and make a decision at that point, okay?
Yes, sir.
All right, okay. All right, is that sufficient, madam?
Yes, Judge.
Okay.
Thank you.
All right. All right, summon our jurors, please.
Do I leave out?
No, sir, not yet.
All right. He will just call in the jurors, say, you're off. And then he goes to lunch. And let's see, timestamp 2:35. That's an hour. That's an hour 15. That's an hour and a half. Yep. His 1 hour lunch, 90 minutes again. As I said. And this is why it's such a cluster F. Now let the faster clock continue. The lawyers will keep pressuring this judge at any point in time because they see clearly he is losing it completely. And the longer this charade goes on, the more in trouble Judge Glanville will be, in my opinion.
Yes, sir. Everybody's ready.
Okay, all right. Counsels, I have a letter from one of our jurors, which I'll mark as the next course exhibit.
T. Underwood, did anyone notice the judge and Miss Hilton exchanging signals? Well, I wouldn't be surprised, but she's doing that whether he's looking at her or not. She has those tics. So I wouldn't put too much thought into that, at least not at the moment.
In order. And because it references I'm not going to disclose what type of procedure our juror is going to have, but it'll be on the 17th of July. So we're going to take an administrative. I think we're going to take an administrative day anyways for that particular day, 17 July. So you want to mark your calendars accordingly. We're going to take the day on that day. If you want to come up and take a look at it, it's just not for public consumption, okay? But
I'm not entirely sure there will be a trial on July 17th, but you never know. And I'm still going to the United States in August. I'm still going to be in Atlanta, August 14. And if the trial is still happening, I will get myself into that courtroom. And then we will see if I am allowed to leave voluntarily or in handcuffs.
going to have a procedure, and you can see which juror it is, but we'll be down that day. Yes.
Yeah, Judge Glanville and the prosecution, they want a conviction, no matter the cost, because they know the appeal will take years, if not a decade, before the appeals court can go through all this faster clocks. And by then, he will be retired and doesn't care anymore. He could proudly say, "Oh, the appeals court was wrong. I was a perfect judge." No, you're not. You're not. I said it yesterday, the day before. The only time this judge should be allowed back into a courtroom is if he is the defendant.
In reading that, it looks like she needs.
No, she does not need that. She's going to do a prep later. Okay.
So that-
She's going to do a prep that evening. Just
They have Miss Bumpus as witness who can testify to the accuracy of that. And she's already not happy with that judge. So if they haven't crossed all T's, dotted all I's, she will tell everybody, I hope.
the 17. Does anybody have any objection to the court sealing that particular exhibit?
No, nothing to say.
Anytime? Okay, all right, okay. Just so you all know. All right. Okay, can we bring back in Mr. Arnold, please? Mr. Copeland, I should say. Mr. Copeland. Again, okay, did you have an opportunity to talk with your client, Mr. Copeland?
Yes, Judge, can we talk about it?
Yes, you can, go ahead.
Yes, and I got him to sign a written consent discharging me. I filed a motion to withdraw and I proposed that.
Okay, can I see it, please?
May I approach?
You can.
Yeah. Dun, dun, dun.
Okay, I'll mark this as the next court's exhibit in order. Do you have a formal order that you're going to prepare with the style of the case and the case number?
Yes, Judge, that's just his signature. I prepared an order and I filed a motion with the clerk's office. I'm waiting on the file.
All right, okay. Mr. Copeland, let me hand you. This document, did you read and sign that document?
Yes,
All right, did you have an opportunity to talk with Ms. Bumpus to your satisfaction about pros and cons of her withdrawing as your counsel in this case?
yes,
Do you wish for her to go ahead and withdraw as counsel?
yeah.
Okay, all right, let me have that back in my mind.
And guess what's going to happen next?
Okay, I'll mark this as the next court exhibit in order, madam. We got it. We'll just mark it as the next court exhibit in order. Do you need a copy of it to file with your, because it'll be made part of the record, but do you need a copy of it?
No, Judge.
Okay, all right. All right, so I will go ahead and authorize you to withdraw as his counsel in this in this matter, okay?
Thank you, Judge.
Okay.
I'm excused.
Not quite yet. Madam,
Yeah. And here we go. Corrupt Judge Glanville keeps digging the hole deeper.
as a result, I'm going to also have you appear on the 25th of June. I have filed an order to show cause, and I'm going to give you a copy of it.
I have that order of show cause, and it's ridiculous. I think I read it the other day as well. Did I read it yesterday? I don't remember. I can read it again in the breaks and stuff like that if we need to fill time, so to speak, because it's so stupid.
You can read it, acknowledge it, just that you received a copy of it, and we'll see you on the 25th of June at 9
Hit the thumbs up, folks.
in courtroom
You haven't.
1C.
All right.
So you need to be here for that day, okay?
Okay.
All right, we'll see you then.
Guess who's not invited to that show cause hearing? The defense attorneys. Strange, isn't it? Well, he kind of has to. And here's the thing about that show cause hearing. Since he is a witness to it, he should not be able to be the judge of it. I would assume. Oh no, that hearing will definitely not be streamed. That will be a closed hearing because this judge does not like sunlight on his misdeeds.
All jurors present, sir?
Yes, sir.
Summon our jurors, please.
And for you wonder, today's the court stream has started, but nothing. So they still haven't started.
All right, Ms. Hilton, you may continue, madam.
And here we go with more photos and stuff, which is completely meaningless.
When we
And
left,
this will happen the rest of the week. This is why I do recap of the afternoon, the day after. That way I can cut out bullshit or decide it's enough with a 1 hour recap later, because nothing happened. But you never know, because this judge is losing it.
I believe that I'm showing you what's been marked as Exhibit 373 Yankee. Looking at what's in front of you as 373 Yankee and what's on the screen, does that appear to be the same image that's in front of you?
It looked the same.
Okay, and is the image on the screen clearer for you than the image that's in front of you?
No, they look the same.
Okay, if I enlarge it, are you able to tell who's in the picture in 373 Yankee by me enlarging the picture on the screen?
No.
No. Now showing you 344 Yankee.
Which one it is?
Is this 348 Yankee, my apologies. Is that 348 Yankee in front of you?
You already showed me that one.
Okay, and before I think you said it was blurry as well
No, I answered you.
for this one. I want to admit if I haven't, thank you so much for correcting that 348 Yankee. You're like, it is 348 Yankee.
Any objection to states 348 Yankee? All right, states 348 Yankee is admitted. It's already been. I thought it was admitted already.
It could have been.
Oh, I thought it was admitted already. 348 Yankee.
Stacy said 344 Yankee. Were you able to identify who was in 344 Yankee?
No,
Okay. And why is that?
it's blurry.
That's the one I spot. Yes. You're welcome. Looking at 60 to 344 Yankee that's in front of you, is that appears to be the same picture that's on the computer screen?
It looked the same.
Now, if I blow up or enlarge 60 to 344 Yankee, are you able now to see the individuals that are inside of the picture? Yes.
Yeah.
Okay, if you can tell us who's inside the picture now that it's enlarged.
Excuse me.
Can you tell us who's in the picture?
Me?
Yes. Who else?
Rapper
Ron
Lil Boosie.
Barnes, how long will he be up there?
Shannon D.
Apparently, the
And it looked like
prosecution
other Lil D.
will have an
I
on
don't know the other
direct
guy.
the rest
All right,
of the
so both
week.
of these are in that picture.
That's what I said.
All right.
And
You're on
remember,
this
the
side, so
judge
you're
is
like,
blaming the
60 to
defense
344.
for this trial taking
Any
long.
objection to states 344 Yankee? All right, hearing none, it's admitted and may be published as you see fit.
Next, Mr. Cole, I'm gonna show you 164 Echo Golf Echo Hotel Echo Juliet, Echo Kilo. I think before I might have said Echo India. It's actually Echo Lima. Can you flip through those and tell me if you recognize who's in these pictures?
Let's speed this up. 1.5. Vintage CB, yeah. I do know that the have they started really? Yeah, they have started today just a few seconds ago, but I'm going to play
There
a
you go.
bit here. Then
First start
I'm
with
going to
6
read from the
Echo Wolf. Do you recognize who's in that picture?
emergency
Nope.
motion that was filed from
No, I
Mr.
can't.
Steele.
Why is that?
This is
That
blurry, I
way
can't see.
we can get caught
Look at
up
164.
and see if anything interesting happens in today's trial.
Are you able to recognize who's in that picture?
Yeah, me and Young Thug.
John, this I seem like 164 Echo Hotel is evidence.
Any objection to states 164 Echo Hotel?
Not on behalf of Mr. Williams.
All right, it's admitted, may be published as you see fit.
Okay, next 164 Echo Juliet.
Hey, thank you.
Me and Duke.
Your Honor, this time the same like attended 164 Echo Juliet is evidence.
Any objection to states 164 Echo Juliet?
Your Honor, may I just take a peek at that?
You certainly can.
And while they are looking at pictures, I want to remind you that this channel is being kept afloat by your contribution. So it's time for the one. Yes, folks, this channel is being kept afloat by super chats, gifted memberships, through PayPal,
Okay, thank you.
or super thanks or stickers or whatever. So if you have the means, don't do anything you can't afford. But if you have the means, I would deeply appreciate a monetary token of appreciation. Let's just put it that way. So thank you so much. That is my one. Let's see what's going on for me the rest of the week. Well, tomorrow is Thursday. More of this. Friday, recap. Here's the thing. If it's completely uninteresting, I might not stream live from this trial because
Any further objection to states 164
so
Echo
I will
Juliet?
keep it to a late afternoon recap.
Can I see it, please?
Condense the day for you, so you don't have to sit through all of this absolute borefest. And Friday evening, it is
All right, Mr. Steele and Ms. Hilton.
finally Friday casual stream with sovereign citizens and beer. So join me Friday afternoon US time for looking at, laughing with, or at sovereign citizens. Okay, so that is rest of the week. And Saturday, it is the Jodi Arias trial, which we are revisiting, me and Dave. And we are getting closer and closer to the end of the trial. Also on Saturday is Serial Killer Saturday, where I keep you updated on current serial killer trials or cases, and revisiting old trials. Currently, it is Eileen Warnes, who killed at least 6 men in a 1-year span in Florida about 30 years ago. Oh, I almost missed it. Okay. Yeah, you see it. I see it. It is sidebar counter 204. Oh, this is so stupid.
Your Honor, it's 164 Echo Juliet.
Yes, it's admitted with the court's instructions.
Thank you, Your Honor. And next, who's in 164 Echo Kilo?
Me?
Okay. Your Honor, this time the state would like to tell the 164 Echo.
Hold on, let me make sure they me.
Make sure. Is it you?
Yeah.
All right. Your Honor, this time state like to state the 164 Echo Kilo is happening.
Any objection states 164 Echo Kilo.
On behalf of the court.
It's admitted, thank you.
And the state is
May be published when you
Yeah,
receive it.
this is the best sound I can have. I can lower my microphone so you can overall keep the sound up. Hold on.
Me?
Anyone else?
There, I lowered
You
it
look
a
like
bit
the
so you
background,
can
but I
raise
can-
the
I can really
sound
see your face.
yourselves
Your Honor, this time the state would like to tell
without me barking in your ear on occasions.
Any objection states 164 Echo Lima.
Foundation.
I sustain it as a foundation. You can lay one more foundation.
Haha, he sustained one.
Is that you in the picture?
That's a rarity.
Is that you? Is that yes or no?
What did I just say?
I'm asking you again, Mr. Copeland. Is that you in the picture?
I just said that with me.
Okay, and the person in the background, are saying that you think that it's stud. How do you think that it's stud? Why do you think it's stud?
Because the other picture you showed me, it was me and Doug.
Your Honor, this how the state like to take the 164 Echo Lima as evidence.
I'll hold firm. Same objection.
I sustain the objection.
Do you remember, your Honor, this is already admitted.
Just because you showed one picture with Thug and then a subsequent photo that was similar. This is such a bad, I mean, the prosecution is doing such a bad job. And they get paid for this. I mean, the average salary for assistant district attorneys in Fulton County is around $120,000 a month. And this pile of manure is what your taxpayers' money is getting you. Absolute horse shit. No, it's not. Horse shit is actually valuable. This trial isn't.
These exhibits are already admitted. 164 Echo itself is admitted. These are excerpts from 164 Echo.
When was 164 admitted, Christina?
That would have been with Agent Racy a few weeks ago.
All right, fantastic.
164 Echo.
So a year, 120 a year, sorry.
I have Echo 164 Echo, Echo Alpha, Echo Bravo, Echo Charlie, Echo Delta, Echo Echo, and Echo Foxtrot were admitted.
Yes, and those are all the full records of Mr. Williams, for which these pictures come from. So this section.
And skip ahead to another sidebar, which brings us to sidebar counter 205. And look at that. Thank you, Vintage CB, for becoming a member. Thank you so much. It is very, very much appreciated. Thank you so much. Let's see. Yeah, thank you. I'm trying to improve the thank you with pictures and applauses. Thank you. Did I count this attempted sidebar without a defense? No, I didn't. I'm counting the trial sidebars. And that sadly does not cut it. But thank you, Vintage CB. Now you have access to all my members-only content, and there are many, many hours just for you. And in my members only things, it's not as much law as it is me. The farm, the renovation, my tractor that says fuck, and stuff like that. Yeah. Thank you so much again. Can judge appoint a public defender temporarily as Mahira? Yes, you can. We have seen this in other trials when a witness does something unexpected that warrants them representation. The judge can, in principle, tell the bailiff, go out in the hallway and find me a lawyer. Because this person needs one, unless they say otherwise. And I am keeping track of what's going on in today's trial, and it's more or less the same as now.
Yeah, I see it.
Okay, now, enlarging the picture, before you said, did you say that this was blurry too?
Yeah, there's blurry too.
So we're saying that you cannot see who is in 164 Echo.
I cannot see who in it on the computer.
All right, now I'm gonna start publishing a few pictures. I'm gonna first publish what's already been admitted as 56W.
Oh crap, the wall of doom. There. Oh look, a picture.
Looking at 56W, who's in that picture?
Me and y'all. Not
Not that you recall, all right.
And
it's like it's a square.
now they are.
What's next to that?
Now this is kind of interesting because this is one of the few times where they actually care about the metadata behind the picture, because the prosecution has submitted videos and pictures that are reposts from others, where the prosecution really can't assert the accuracy of the pictures if they are doctored or not. That is still being admitted as evidence in this fucking trial. Hey! Law of self-defense. Hello, Andrew. Good to see you. Good to see you. Thank you so much. Thank you. Alpha, Bravo, Charlie, Delta, Echo, Feces. Yeah. Damn, Andrew, did you watch what happened earlier this week? What an absolute fustercluck. What exactly are these pictures showing? It's showing that Woody knows Stillwell, he knows Young Thug, and that is the prosecution's attempt to prove that he is an associate of the YSL gang in order to further the conspiracy charge in the RICO trial, in the RICO Act. Andrew says, yeah, I saw the contempt matter solution. Don't live in Fulton County. Yeah. And I'm testing my faith by going to Atlanta in August. I can send Andrew an invite if he wants to join us and talk about the contempt thingy. You want to come on for a bit, Andy? Andrew, if you have the time, I will send you a link, and you can choose. Dun, dun, dun. There. I sent you a link. You choose if you want to come on or not. Hey, nice.
WODDIE, Witty.
Okay. And do you see the same Instagram name?
I think our audience would like the break,
372.
would
All
like
right.
the
And
slight
again, that's
break
you in
in
the same
this
picture.
What's that?
bore
Is that you
fest.
in this picture?
Yeah.
At the top. And they call you Booty, right?
WOODY.
Okay. And what does it say next to that?
ELATT.
Okay. And what's it next to that?
SLATT.
Okay, I know you spelled. Have you heard the term black and slack before?
Yeah, I heard it.
Okay, is that what that say? Black and slack?
I guess.
All right.
Let's go 164, Echo, Juliet.
I got set up again.
If you can't see on the side, yes.
Hello, Andrew.
Hey, hey, how's
Hey,
everyone doing?
For a few days, this trial got really interesting, at least for the general population, because I've been screaming from the rooftops about this judge for months. Almost downplaying it because when I say all of it, it sounds too much, and then all of a sudden, this happened. What are your inputs on this?
You're
Andrew?
doing God's work, Nick. So a couple days ago, I was on a motorcycle trip with a buddy of mine, and we have intercoms in our helmets so we can talk to each other. And we stop for gas to use the bathroom at the gas station. He goes in first, and his intercom's still on, and I can hear him. He walks into the bathroom, and he's like, "Oh my God, the stench!" And I decided right there I wasn't using that bathroom. Every time I see you cover this trial, that's the same feeling I get.
Yeah.
I catch just a few minutes of you live streaming, and I'm like, oh my God, the stench. I can't take it. You're doing God's work, man, for putting in this kind of effort. Are they 2 years in?
They started the trial in itself started November 28th. The jury selection started January 4th last year.
2023?
Yeah.
And obviously, yesterday gave the whole game away. This judge is out of his mind. He's out of his mind having an ex parte meeting in a criminal case. He's out of his mind, unable to differentiate between civil and criminal contempt, unable to process any of the arguments he's receiving from counsel in defense of poor Attorney Steele. Attorney Steele's like Gladiator.
Yeah.
He's awesome, man. I think he's doing exactly the right thing, of course. Yeah. And if he has to do 20 days in county jail, he'll do those 20 days with full honor. Full honor.
He will serve it on weekends with Young Thug, with Mr. Williams, with his client, so they can prepare.
They're going to have him in the same cell? They're going to do judge allowed? That's great.
Yeah, in jail together at least. So he can prepare with his client during the
weekend.
Well,
if this trial keeps up at this pace, Young Thug may emerge as a paralegal.
Yeah. And I mean, I've been saying so many words about this judge. So I'm so happy that people start to realize it really have been this bad. But also realizing that this judge does not know the difference, as you said, between civil and criminal contempt. So how many times, for how many years have he done this in trials nobody cared about?
Right. Yep. That's why I always tell my community, don't be getting into fights you don't need to be getting into, because you could end up in front of a judge like this. All the people who say, I'd rather be judged by 12 than carried by 6. Well, of course, if that was the binary solution set, you'd rather be in court than be dead. But keep in mind, being tried by 12, that's no party. And that assumes the 12 are sane individuals, and the judge is sane, and the prosecutor is sane, and your defense attorney is capable. None of those things are necessarily true.
No. And here you have if this trial goes on for more than a year, which it will, this is a $10 million trial for the prosecution alone. And
but they have to be so it doesn't matter to them. They have to be on the job anyway, right? So if they weren't in court on this case, they'd be in court in some other case. So it's a wash. The taxpayer's paying that.
Yeah. And the people who are paying it is all the trials that could have happened instead of this one. There are victims out there that have been waiting for years to get justice. There are defendants out there that are waiting to be acquitted.
It
They
would be
are-
interesting to talk to some local Fulton County defense attorneys and ask them, hey, is this changing how aggressive you are on your speedy trial rights for your client?
Yeah.
Because a lot of times defense attorneys, they'll waive speedy trial because
Mm.
the faster they get their client, most criminal defense attorney clients are criminals. So the faster you get your client to trial, the faster they get convicted, the faster they go to prison. So
Yeah.
sometimes it's in your interest to delay the
Yeah.
trial,
Mm.
although you have the right to demand a speedy trial.
Mm.
But now, if
No,
you
I-
can demand a speedy trial and the state can't be ready,
Yeah.
there go the charges.
Yeah. I mean, you have the lead attorney. He's local for Atlanta, but he's retired. You have this Inside the Law, a relatively new channel. He's also local. So I've been trying to reach out, but now they are covering it. So they don't have interest in my little channel here. So I'm very
They're
happy.
covering it as of yesterday, you mean, because of the contempt, or they were already?
Well, lead attorney have been covering this from time to time on his channel.
Right.
But I understand why nobody wants to cover it to the extent I do. And the only reason I do it is because I promise my viewers I
Yeah.
will see them gavel to gavel.
It's tough, man. I mean, that's one way for a judge to avoid public scrutiny of his proceedings, even if he's
Yeah.
required to have cameras in the courtroom, is make it so boring that no one wants to watch and nobody wants to cover it.
Yeah. And unlucky for him, I do labor law. Everything
And-
I do is boring.
And this is a jury trial, right? So the jury's been sitting there this whole time?
Yeah.
Since January of 2023?
No, they were starting the jury selection in January of
Okay.
2023. They were seated mid-November for
All right.
waiting the trial.
So still,
But
that's
they were
7
told
months.
Yeah, they were told on day one, this trial will take several weeks, probably months. That was all they were told. Now they are almost 7 months in.
Yeah. So to put this in context for folks, a typical murder trial is 2 days.
Yeah, I mean, the guy in Florida, the double murder death penalty case, started Monday. Today is the prosecution and defense closing arguments.
Well, that's quick for a death penalty case, but
Yeah. Now now they found him guilty, probably because I mean the evidence is so clear. And then you have the death penalty phase, which is a different. So everything was scheduled for 3 weeks. But
both,
the actual
both parts.
Yeah, both parts.
Well, that's Florida, man. Don't go committing capital crimes in Florida.
Yeah. And
It's funny.
I
So
mean,
I heard someone sent me, my moderator, Shane Souza, sent me a video clip today of a Florida judge getting chastised. So this is a chief judge of a judicial district in Florida. That's a big deal. Getting chastised by the Florida Supreme Court in public, live streamed, because when she was interviewed by a judicial committee they asked her about her driving record, and she didn't tell them that morning on the way to the meeting, she got a speeding ticket. And because of that, I mean, not even convicted of speeding, just, a ticket's just an accusation of speeding.
Yeah.
Because she didn't share that information with judicial committee, she's being publicly castigated by the Florida Supreme Court, which is fine. I mean, if that's the standard the Florida Supreme Court wants to apply in terms of ethical requirements for its judges, I don't have a problem with that. I mean, I think it's a little silly. I mean, since she wasn't even convicted of speeding, but compare that standard to what this judge is doing. I mean, this is insane. There's no control over this judge. How would you ever practice law in front of this judge? Every time you go before him, you don't know. I mean, is he going to ask you, hey, did your client tell you that he committed the crime? It's like, Your Honor, I'm not going to tell you that. Well, 20 days, 20 days contempt.
And I don't know if you heard this, but allegedly in that secret ex parte meeting with the prosecutor, the judge, the witness, and his representation, allegedly he confessed to the murder they are charging Mr. Stilwell.
So it's exculpatory evidence.
Yeah, and the judge refuses to release the transcript because he said no, it was a civil matter. It doesn't apply to this trial. He's the witness. How does this not? I mean, it's so mind-bogglingly stupid. But I'm starting to realize the judge thinks he does right. He thinks the law is this way.
Maybe there seems to be it's almost a feminine level of delusion taking place here. The law is whatever he wants it to be in his current emotional state in the moment. It's but this is what happened. So here, I don't know if they have this where you live, but here in America, we have something called homeowners associations where you can buy a house in a community and they have rules for what you can do, right? What color your house needs to be, where you can park your car, all this kind of stuff. And someone has to be in charge of the HOA, the homeowners association. And the person you want in charge of that is the person who does not want the job. You want someone in there who's going to do the absolute minimum. Because if you give that job to someone who wants it, you end up with a little Napoleon. He'll start walking around with a fake police badge, ordering people around. First time in his life, he's got a little authority. That's what this judge feels like to me. We made a guy a judge who's got psychopathic tendencies.
Yeah, and I can only, well, we do have equivalent of homeowners associations, but not to this level. But we do have the Swedish version of school PTA. And those are insane. My sister is a teacher up north, and she says she dreads those meetings because they are absolutely insane. These are parents who were coddled. The parents now are the ones that were coddled into life 20 years ago.
Yeah.
And now they think everything surrounds around them. They are the prince and princesses in their own universe, and everybody has to treat them like their parents treated them. And they have a hard time in the workforce, especially if they screw up and get me as representation, because I don't give two shits on a straw about their feelings. I apply law, tactics, and save what can be saved. I don't give a shit about their feelings.
Yeah. Well, we live in an increasingly low competency society, and that includes being emotionally driven, right? And not being constrained by reason, rationality, rules.
If I was on this jury, I would have to be excused. I'm allergic to blatant stupidity. Yeah. I mean, one jury.
I mean, how can you be on a jury for 7 months, right? These juries are getting paid, what, $12 a day and a bologna sandwich at lunch? I mean,
no, $25.
What kind of person can take 7 months out of their life to do this?
$25 a day, and they no reimbursement of travel, no lunch, because that is not in the court's budget.
No lunch, so they're eating that shitty food around the courthouse for 7 months. Oh my God.
Yeah, and they are €3 down. 12 or they had 12 plus 6. Now they have 12 plus 3. I was actually expecting more jurors finding excuses, because one had to leave because of medical reasons. One moved out of the county, so they couldn't be a juror anymore. And the first left after just a few days because of other reasons.
Oh my God, I would move out of the county so quick.
Yeah.
I love this house, honey, but we got to move.
Yeah, I mean, people are going bankrupt over this case, over this trial. The jurors, some of the defense attorneys who are public defenders. I mean, and then you even have, because there were so many defendants, they have to call in people who didn't know better. And the original offer was $15,000 for the entirety.
Oh no, that's what the defense attorneys took?
Yeah, because at the beginning, it's cool, plead out, easy money. No.
Have any of the lawyers gotten out? Any of them been released?
No.
No. Have they tried?
Yep.
Yeah. And the judge won't let him go.
Yeah. The latest offer, at least, they put it up to the sole remaining private practice lawyer, defense attorney, is getting paid $5,000 a month.
Oh,
Yeah. Whoa. 60K a year. Woohoo. And she has to be there every day. She can't take other cases.
oh my God.
I mean, it's
And Atlanta's not an inexpensive place to live, folks.
no. Oh. Oh, let's see here. And this is, by the way, is Woody, Mr. Copeland. On the third question he got on Friday, he pled the fifth. And he was held in contempt and sat in jail over the weekend. And Monday.
Is he a defendant? What's his status?
No.
So just a witness.
He is a witness that used to be a part of the indictment.
Okay, all right.
But no longer, apparently.
Did they grant him immunity?
Well, in order for him to not plead the fifth, the prosecution offered him immunity.
Right.
Because apparently county immunity erases the Fifth Amendment. Which I think it's stupid. What if he says something that is a federal crime?
Yeah, I have to be honest. I don't know how that works. We'd have to ask an expert on immunity law because the cases I've worked where we had where immunity was involved, there was no, apparent path to getting to federal jurisdiction. They were just purely local crimes.
Yeah.
But anytime there's guns and gangs and drugs related, there's always some potential for a federal indictment. And you're right. Just because the state's giving you immunity, that's not a constraint on the federal government. Unless a federal judge wants it to be, but I mean, the judge could say that, but that's within his discretion. You wouldn't know that going in.
Yeah. We simply don't know what he is going. Now he has been then the first o'clock happened yesterday, of course, with the secret ex parte meeting. And now he's fired his stand-in lawyer because his original attorney had unrefundable airplane tickets. So he asked a friend attorney to stand in for him on the contempt hearing and the contempt hearing alone. And the judge has so desperately wanted her to state that, well, you can recuse yourself, but then he has a 10-day period where he can object to it. And he has said on the stand twice, she is not my lawyer. She is fired. Yeah. I mean,
there are circumstances. I mean, the notion that a judge would deliberately participate in an ex parte meeting like this is insane. Yeah. I mean, this kind of thing sometimes happens by accident. Like a judge might be on an elevator and he's reading a newspaper and one of the parties gets on the elevator and starts talking and he overhears it. But that's an ex parte meeting, but it wasn't intentional. And the first thing that would happen is they'd get back into the courtroom and the judge on the record would say, listen, I have to inform the parties that this event occurred. It was incidental. It was unintentional. This is what I overheard, so that there's complete transparency. But the notion that the judge is meeting with one party and not the other in a criminal case and did it deliberately in chambers is insane.
Yeah.
All right, man, that was my alarm. I got to go.
Okay.
Thanks for having me on. Sorry, it could only be
Thank you for being here.
But you're doing God's work, Nick. Keep it up, and good luck, and have a great week, everybody. Bye-bye.
Thank you. Bye. All right, let's continue. Let's see first if anything interesting is happening. In the other hearing. Okay. Not much is happening in that other proceeding, but here we are. Another picture. Here we are with some metadata. See here. That's another picture.
Okay.
roughly? Do you know about when they were taken?
Is it like in general? Like, I don't know what you mean.
Sure. Were those pictures taken like 2014 and 2015? You were hanging around?
Your Honor,
Sir,
I do have an objection.
Basis.
Form of question, and I don't know exactly what
I
picture.
sustain the question.
Looking at those pictures, about how old you were when you took them?
Okay, which pictures are we talking about? Because it's kind of,
And I know what I was trying to.
You know, you have the discretion to tell them to move on. You actually do.
I'm gonna start with 56.
But you want a conviction too.
You gonna
That's
show
why
me?
you don't. Oh, look, another picture. And a picture.
No, yeah, my question. When you took that picture you just saw 56W, would these pictures be taken around the same time, same year, 2014?
And then they went on a break. And then this happened. Sidebar counter 206. Yeah, we are moving into today's trial. I'm just showing you. And
we're no problem. I'm just going to recess and duration of Mr. We are going to we just talked our conversations about the length of and duration of Mr. Copeland's testimony. So, but for purposes of today, we're no problem. I'm just going to recess and as soon as the jury comes out. Okay. So we'll recess for today. We'll start back up tomorrow morning, 9:30 for a 10 o'clock start time. All right.
he didn't start at 10 o'clock today.
Go ahead and call Mr. Copeland back in, please. We have come to a point today which might be a natural stopping point for us today. So I'm going to recess you all until tomorrow morning. Tomorrow being Wednesday, we'll start. You all need to be here for 9:30 for anticipate 10 o'clock start time, and then we'll see where the day leads us. Okay. All right, Mr. Copeland, we'll see you tomorrow morning at 9:30. Okay.
I can go
For today. Yeah, for today. We're done for the day.
right
Yeah.
now?
Yeah. We'll see you in the morning at 9:30. All right. Yes.
All right.
Okay. All right. Okay. Go ahead and review our nightly admonitions. Remember, you may
Blah, blah, blah. You can't talk to anybody. Please don't talk to
Remember, it would
anybody.
be a
Please
violation
don't
also for you to
find
go by
out
and
I
visit any of the
am a
scenes
complete
depicted.
moron.
Visiting those scenes. Party seeks to tell Joe.
Dun, dun, dun.
All right. Anything about any defendants?
Can I just inquire if there's an estimate of time on direct? I understand that it may be lengthy, but all week, is it 2 weeks?
I was just saying up here at the bench. They'll have the ability to listen in, but I'll repeat it. At least till the end of the week, possibly in the next week.
Okay, and the reason I asked, I filed a motion, Your Honor, yesterday morning, which is 6/10/2024. This entitled motion for correct rulings on improper objections by the state. I just want to make you aware before cross-examination. I raised 2 issues about the objections.
Is this about I do recall you reviewing that particular motion, and yes, we can hear it prior to.
Thank you.
Just remind me again, just to make sure I flag it again. Yes, sir. All right, Mr. Sharp.
For recoverage, another courtroom for Thursday is needed. We know our schedule for Thursday.
Thursday, as of right now, Mr. Sharp, Thursday the 13th should be a regular workday.
Okay.
All right. Anybody else? Okay. All right. Unless there's anything else, councils, I'll see you all tomorrow morning for 9:30 for anticipated 10 o'clock start time. Okay. All right. We're in recess.
We are doing, yeah. We just did the recap of yesterday. So everybody was caught up because I ended just before lunch yesterday because I had 2 hours of sleep the past 2 days and I needed to get some rest. We will move into today right after, because as I promised, we are going through this. The emergency motion for superseded bond on criminal contempt. This is regarding having Mr. Steele out on bond on the contempt hearing, that he doesn't have to be in jail. And this is because we know that Judge Glanville, there will be breaks, there will be everything, so we can skip over the absolute uninteresting things and keep to the important things. So, and this also will be as a separate video for, yeah. So, in the Court of Appeals of Georgia, State of Georgia, Brian Steele movement, case number, well, emergency motion for supersedes bond on criminal contempt. Comes now. Movement, Brian Steele. Here and after, Mr. Steele, by and through undersigned counsel, and files his emergency motion for supersedes bond on criminal contempt pursuant to Court of Appeals Rule 40B. And support of this emergency motion, Mr. Steele shows the following. Mr. Steele is lead counsel of record for Jeffrey Williams in State of Georgia v. Jeffrey Williams et al. Indictment number list. So this is just basic facts. On Monday, June 10th, the trial judge, along with the state prosecutors, engaged in an ex parte hearing with a sworn witness, Kenneth Copeland, for whom an order of immunity from the state prosecution had been issued. No notice of an ex parte meeting involving the state and the sworn testifying witness was provided to any attorneys for any of the defendants in the case. The witness had previously been called to testify on Friday, June 7th, 2024, asserted his Fifth Amendment privilege in open court at that time and was held in contempt and summarily incarcerated until such time as he agreed to testify for the state pursuant to the grant of immunity. Judge Glanville and the prosecutor admitted in open court that an ex parte meeting occurred on the morning of June 10th, 2024. When trial reconvened on June 10th, 2024, Mr. Steele informed the court that he and others had learned, based upon information and belief, that an ex parte meeting with a sworn witness occurred earlier in the day. Mr. Steele proffered his understanding that the witness had made factual admissions to criminal conduct, which the state intended to use against Mr. Steele's client in its case in chief, and that statements were made to the witness about the amount of time he could be held in custody on the contempt. After the court acknowledged the fact that the meeting had occurred, Mr. Steele demanded information regarding the meeting, including the names of everyone who was present, requested a transcript of the proceeding, and made a motion for mistrial on the grounds that an improper ex parte hearing was conducted with the sworn witness, which violated Mr. Williams' constitutional and statutory rights, including the right to due process and a fair trial. Hi, Christine. The trial court rejected Mr. Steele's substantive request for information about the ex parte meeting, and the court denied Mr. Steele's motion for a mistrial. However, the court instead demanded to know how Mr. Steele came into possession of the information about the ex parte meeting. And here is the footnote. Citing State of Georgia Bar Rule 1.6, confidentiality of information, Mr. Steele declined to provide that information requested by the court. Rule 1.6 states in pertinent part that A lawyer shall maintain in confidence all information gained in the professional relationship with a client, including information which the client has requested to be held inviolate, or the disclosure of which could be embarrassing or would be likely to be detrimental to a client unless the client gives informed consent, except for disclosures that are impliedly authorized in order to carry out the representation or are required by the rules or other law or by order of the court. Comment 5 to Rule 1.6 specifically states, now this is important, folks, because there you have rules and then you have comments to that rules that teaches the reader how to interpret that rule. And the comment says, the principle of confidentiality is given effect in two related bodies of law, the attorney-client privilege, which includes the work product doctrine. Work product doctrine is what you learn from other sources during your representation of your client. That's the short version. There are longer versions. And the rule of confidentiality established in professional ethics. This is highlighted. The attorney-client privilege applies in judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. This is what Judge Glanville tried and failed. The rule of client-lawyer confidentiality applies in situations other than those where evidence is sought from the lawyer through compulsion of law. Rule 1.6 applies not merely to matters communicated in confidence by the client, but also all information gained in the professional relationship, whatever its source. So here, Judge Glanville and Prosecutor Love, Hilton, and the rest of the pack is wrong. They know they are wrong. I can almost guarantee they know they are wrong, but they also can't admit they are. They are digging the hole deeper. A lawyer may not disclose such information except as authorized or required by the Georgia rules of professional conduct or other law. So he can't, even by court order, he can't, because it's the Georgia rules of professional conduct or other law. That's the only way that information can be disclosed. Let's see here. Dun, dun, dun. Let's go move forward with the client's policy goals. 7. The court repeatedly demanded that Mr. Steele reveal the source of the information, claiming that the way that Mr. Steele obtained that information was unlawful, and baselessly accused Mr. Steele on the record of potentially acquiring the information through eavesdropping. In response to the accusations and demands of the court, Mr. Steele relied on the ethical mandate of Rule 1.6 and the Fifth Amendment right to remain silent when accused of a crime. Yes, folks, eavesdropping into the court chambers or whatever, that's an actual crime, which automatically Mr. Steele have Fifth Amendment rights, and that is to remain silent. So he has two ways to keep his mouth shut. And declined to provide the source of information which had been proffered. The court held Mr. Steele in criminal contempt for refusal to provide the source of the information regarding the ex parte meeting, and the court ordered that Mr. Steele be taken into custody until such time as he revealed the source of the information about the ex parte meeting. The court did not enter a written order at that time. No. Judge Glanville only did it after he was schooled by Ashley Merchant. Then he made it written, and it was so poorly written. The court thereafter permitted Mr. Steele to participate in trial for the balance of the day, but indicated that at the close of business, it would again address the content matter and demand that Mr. Steele reveal the source of the information regarding the ex parte meeting. At the end of the trial day, the court again took up the issue of contempt and demanded that Mr. Steele reveal from whom he learned about the ex parte meeting with the sworn witness, Kenneth Copeland. Mr. Steele again declined to disclose this information, citing the relevant privileges. The court reiterated that it was holding Mr. Steele in criminal contempt and that he could only purge himself of the contempt by informing the court from where he obtained, quote, information that he shouldn't have had. Mr. Steele informed the court that members of the Georgia Association of Criminal Defense Lawyers were outside the courtroom, seeking to represent Mr. Steele. Undersigned counsel, attorneys Merchant and Susor, were ultimately permitted to enter to represent Mr. Steele, but only after the court had already recommended further discussion of the contempt issue with Mr. Steele without his legal representation behind him, while they were trying to get into the courtroom. After Mr. Steele advised the court he had representation, Judge Glanville kept trying to interrogate him. That in itself, is a no-no. It's a no-no. Following argument on the issue of contempt, the court issued a written order of contempt and incarceration for Brian Steele, finding him in direct criminal contempt and imposing a sentence of incarceration for 20 days. See attached order. We won't look at that order. The trial court order that Mr. Steele will begin serving his sentence at 7 p.m. this Friday, June 14th, which necessitates the instant emergency motion. The appeal that will follow will address 3 issues. First, whether the court abused its authority in presiding over the very contempt hearing that was born of allegation that the court itself had violated the rules governing ex parte communications. Second, whether the court denied Mr. Steele's due process rights during the conduct of that hearing. And third, whether the court abused its authority in holding Mr. Steele in contempt for refusing to divulge privileged information and for protecting his client's constitutional rights to due process and effective assistance of counsel. Regarding the first issue, the court had a duty to recuse from presiding over the contempt proceeding. In such proceedings where the announcement of punishment is delayed and where the contumacious conduct was directed toward the judge or where the judge reacted to the contumacious conduct in such matter as to become involved in the controversy, the judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted by another judge. In Ray Schoolcraft, 274, Georgia, appeals, 271, 271, 617, as a lot of words or numbers. Here, the court involved themselves in these proceedings by conducting the ex parte hearing that violated Mr. Steele's client's rights. This created a conflict of interest for the court because its own ethical conduct was at the heart of Mr. Steele's request. The court then compounded its abuse of power by presiding over the very contempt hearing where its own rules violations prompted the controversy. The court should have recused and allowed the contempt proceedings to be handled by a separate court. As to the second issue, referenced above, the court denied Mr. Steele his due process rights, as Mr. Steele has a right to adequate notice and to be heard, to call witnesses at a hearing, and to be represented by counsel for the entirety of the contempt hearing, which Judge Glanville denied him over and over and over again. As to the third issue, referenced above, an attorney may only be held in contempt for statements made during courtroom proceedings after the court has found that 1, that the attorney's statements and attendant conduct either actually interfered with or posed an imminent threat of interfering with the administration of justice, and 2, that the attorney knew or should have known that the statements and attendant conduct exceeded the outermost bounds of permissible advocacy. Because contempt is a crime, the evidence must, of course, support these findings beyond a reasonable doubt. And you heard the judge say himself, there were multiple people in that room that could have told Mr. Steele that would never reach beyond reasonable doubt. And I'm not even counting in that the ex parte meeting in itself was a violation of rules. Because blah, blah, blah. And when addressing contempt matters, any doubt must be resolved in favor of vigorous advocacy. The Supreme Court has emphasized that, quote, courts must be judicious in their approach to adjudicating contempt, end quote. Precisely because, quote, vigorous advocacy is essential not only to the preservation of individual rights, but also to the integrity of the judicial system, whose truth-seeking process is sought to be protected through the exercise of the contempt power, end quote. Accordingly, quote, the court should always assess whether there are other correctives sufficient to address the problematic conduct in question, end quote. Therefore, quote, trial judges must be on guard against confusing offenses to their sensibilities with obstruction to the administration of justice. That goes directly to Judge Glanville's inability to differentiate between civil contempt and criminal contempt. Mm. 17 here. Mr. Steele's statements and conduct did not interfere with or pose an imminent threat to the preservation of order and decorum in the court or interfere with the orderly process of the administration of justice, as evidenced by the fact that the court was able to continue the trial after its initial oral pronouncement holding Mr. Steele in contempt. Further, Mr. Steele's refusal to disclose the name of the individuals who informed him of the ex parte meeting, which he argued would constitute a direct violation of his duty of confidentiality imposed by Rule 6, in no way delayed or impacted the underlying trial. Moreover, any doubt must be resolved in favor of Mr. Steele's vigorous advocacy on behalf of his clients, especially when he was raising serious concerns about the court's involvement in an ex parte contact with a sworn witness. And finally, I think, a notice of appeal and a motion for superseded bond had been filed in the trial court, and the court orally ruled that it would not grant a bond. Pursuant to Rule 40B 2 and 3, a stamped court-filed copy of the trial court's order finding Mr. Steele in contempt is attached as Exhibit A, and a stamped filed copy of Mr. Steele's notice of appeal is attached as Exhibit B. Pursuant to this rule, Mr. Steele shows that service is being perfected upon the state of Georgia and the trial court contemporaneously with the filing of the instant motion. Finally, pursuant to Rule 40B5, the instant filing is being accompanied by the filing fee as required under Rule 5. Wherefore, Mr. Steele files this emergency motion for bond and asks that this court order that a superseded bond be granted pending the appeal of this contempt finding and the imposition of the sentence be stayed. So that is one of several appeals that is in motion. And I would be immensely surprised if the appeals court doesn't take a look at this and say, oh, somebody screwed up, but you never know. Because if the trial judges are this bad, does that reflect the appeals court? But here's the thing. Mr. Steele, throughout his career, has had 45 convictions overturned. He made appeals court and Georgia Supreme Court write opinions in over 300 cases. That is a whole lot, folks, a whole lot. So, but that was that appeal, the superseded motion, the emergency motion for superseded bond of criminal contempt, and a hope that it puts a stay on him being put in jail. No Kurosan. Do we know if there has been filed anything regarding disrobing of the judge? Well, this, I do believe that Mrs. Steele has filed one of these motions where she claims that this judge needs to recuse himself from this trial. But we don't know yet. We just have to wait and see. We have to wait and see. All right, folks. Now we are moving finally into today. Finally. Let's see here. Bum, bum, ba. Bum, bum, ba. Bum, bum, ba. Oh, no subtitles. Oh, Christ. Oh, well. Not much to do. Sound up. Let's go.
Hi, good morning, ladies and gentlemen. Please be seated. I'm back on the record tonight as Safety Jordan. Et al. In 22 SC 183572. Mr. Stillwell, Mr. Voss, and Mr. Sharp. Good morning, gentlemen. All right, Mr. Williams,
And
Mr.
of
Steele,
course,
Mr.
the-
Adams. Good morning.
Yeah, the usual roll call.
Mr. Kendrick and Mr. Weinstein, Mr. App. Good morning. Good morning. All right, Mr. Yu and Mr. Matthews Jr. Good morning. All right, Mr. Nichols and Mr. Garner. Good morning. All right, Mr. Ryan and Misty Williams. Good morning. All right. All right, Mr. Smith, Mr. Brown, Mr. Atkins, Ms. Love, and Ms. Hilton. Now for the really important people, Ms. Knight, Mr. John. Anything else I need to take up?
I did, we're good.
Yeah, we're skipping ahead, so we get to the more important parts.
All right, sir, summon our jurors, please.
Thank you.
Okay. Summoning jury. Here's Woody, still on the stand. And sadly, no subtitles. No closed captions. I'm not sure if I have subtitles on my stream. Hold on while I check. No, why isn't mine working? Let me go check. I will check if I can get it started somehow.
All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, members of the jury, good morning. All right, we're going to continue with our current witness. Mr. Copeland, you're still on your oath, okay? All right, sir?
Mhm.
Okay, all right. Ms. Sultan?
Good morning. I'm going to show you what's already been admitted as State Exhibit 164 Echo, page 2373.
And it should come up on your screen. Looking at page 2373 of 164 Echo, who is depicted in those pictures?
Me and y'all up.
All right, and I want to scroll down to page 2373 of 164 Echo.
No, Cursan has CC on his law and C work stream. Hold on, I will update and see. Nope.
Got my back. Love him like my mama.
And then does it say who the photo is by? You can scroll over to the right.
Oh, I'm on 11 Alive.
All
Jesus
right.
Christ. Sorry, folks.
Now, thank you, Mr. Atkins.
I will
Since
change.
you've been released from custody in 2019, have you flown on a plane with Young Thug?
I was on probation.
There. Sorry, folks. I did not realize I was on. There you go.
Do you see, similar to yesterday, the date? If you could scroll back up, Mr. Atkins. Do you see that line that says taken?
Somebody at the top over here, same place?
Yes, sir. What is that?
Which one, this one or that
Aaron,
one?
no, I don't have
The one at the
Cash App.
top.
I have
What
PayPal.
about it?
Hold on while
what
I
is the
get you
date?
the. Link.
2014,
And then do you see a number next to the 2014?
yeah, 7-31.
You say that to be July 31st, 2014.
I guess.
All right. Now scrolling down to the text at the bottom, yes, before. If you could please read what the text says.
Who did 372? Got my back. Love him like my mama.
And then does it say who the photo is by? You can scroll over to the right. Okay. It doesn't say who took the picture. All right. Now, thank you, Mr. Atkins. Since you've been released from custody in 2019, have you flown on a plane with Young Thug?
I was on probation.
Okay. So is it yes or no? Have
I
you
can't
flown-
leave. I can't leave the city.
To your knowledge, have you been posted or tagged in any Young Thug picture since 2019?
Not to my knowledge. I don't know.
Since 2019, have you been with together in the club? Not seen him in the club, but you two all actively were together in the club.
You said since 2019?
Yes, sir.
Say, I think you
Yes
could
or
say
no?
something else.
No, I'm waiting for your answer. Yes or no?
Answer to it.
The question I just asked you.
Oh, what is your question?
Sure. Since 2019, have you and Thug been together in the club? Not, I've seen him in the club, but you two actively were at the club together. Either y'all went to the club together, y'all were at the club together. Have you done that since 2019?
Objection, compound.
That's the same question, Mr. Foreman. That was Mr. Matthews Jr. Hey, Mr. Weinstein, do me a favor, push that camera on the top of the podium. Push the camera
At the top.
on the top,
Just press down. No.
press down. Thank you, sir. Appreciate it.
I'll rephrase. Since 2019, have you and Young Thug been together in the club? And I'm not talking about I saw him in the club, but you two have been together in the club.
I can't recall.
Is it fair to say that your relationship after you got out of prison is not the same as it was before you went to prison in 2015?
Huh?
You have an objection, sir?
Yeah.
Basis.
It's an incomplete question.
So the form of the question? I sustain the question. You can rephrase it.
Is your relationship the same with Young Thug since you got out of prison as it was before you went to prison in 2015?
One more time.
Sure.
I'm trying to.
Do you have the same relationship with Young Thug since you left prison in 2019 as you had with him before you went to prison in 2015?
So I'm confused. So help me understand. If you and her y'all got a relationship 10 years ago, so today is y'all relationship the same from 10 years ago today?
Is your relationship the same?
I need an answer.
Is your relationship the same as it was 10 years ago?
I don't think nothing would be the same from 10 years ago. I don't know how to answer that. I don't know.
Okay. Is your relationship better with Thug or worse or the same?
Hey, Christina.
I don't know. I don't know I don't know what to say to that. I don't.
Do you speak? Have you, and this is yes or no, have you spoken with Thug in the year of 2024? Yes or no?
This year?
This year.
No.
In the year of 2023, have you spoken with Thug? Yes or no?
Overrule, sir.
No.
In 2022, have you spoken with Thug? Yes or no?
I can't recall if I was in. I can't recall when did I got arrested. I don't know if it was 21 or 22. I don't want to say yeah or no to it because I don't know if I was on the street or if I was in jail.
Let me ask you this: while you were in prison, did you ever speak with Thug?
No.
All right. Thank you for that. Do you know someone by the name of Marquavius Huey?
No.
Do you know someone named Quay?
I know a lot of Quays.
Okay. Do you see any of the Quays that you know in the courtroom today?
Yeah.
Okay. How many of the Quays do you know are in the courtroom today?
One.
Okay. Can you identify him by article of clothing that he is wearing?
Where he's sitting right there, like I don't know what color it is he got on.
All right. You said over there. Is he sitting? Is it the man with the gray and cream jacket?
This is so
It
objectionable.
shows so reflect.
What? The prosecution is not allowed to describe somebody like this. The identification. Now, welcome to Georgia and Judge Glanville's on Foster Clock Courthouse. But there's only the witness with his own or her own words have to give the description. Instead, Miss Hilton, does he wear this? Yeah. Inappropriate.
Thank you. How long have you known Quay?
Not long.
When you say not long, what does that mean to you?
I don't know Quay like that.
Okay. Have you known him for a year? More than a year?
I haven't been around him a year. So just because I know of somebody, I've been in jail, I've been away. So
are you saying you just met him in 2023?
I met Quay probably, I only knew Quay personally, been around him no less than 90 days, like no longer than 90 days. I don't know. I haven't been around him personally to say I know him that well.
Let me ask you this. In 2021.
Thank you to Serve for your $10 donation via PayPal. That is much appreciated. Thank you for your support of this channel. It is the super chats, the gifted memberships, and the PayPal things. That is what keeps this channel afloat and allows me to travel to the United States in August, where I will be a weekend in Houston, a day in New Orleans, a day in Atlanta, a day in Knoxville, and a day in Delphi, Indiana, and a couple of days up in Michigan. Yes, I am driving through the United States of America in August. Thank you. Thank you for allowing me to do this.
Did you know Quay?
I think that's when I met him.
Do you recall how you met Quay in 2021?
No, I don't.
In 2021, did you consider Quay a friend?
I consider him cool.
I'm going to start in 2021. How often, if at all, did you see Quay?
I don't know.
Would it be weekly?
I seen him when I seen him.
Okay. Would that be once a week, once a month, every couple of days?
I saw him when we had time to see each other.
And I'm asking very specific.
I can't say
how often that was.
When I wake up, my day is not planned. I just go with the day.
And so I'll just ask you again.
Say that again.
Would you see him on a weekly basis, on a monthly basis?
I saw him when I saw him.
Would you speak with him on the phone?
Yeah.
How often would you speak with him on the phone?
When we had to call each other for something.
Did you speak with him on the phone more than when you actually saw him in person?
I spoke to him when we spoke to each other.
Did you speak to him more or did you see him in person more?
What you mean?
Objection made.
I will not do a reenactment of an
What would you
idiot
do? Would you see
abroad,
him more? Or did you
especially
speak
not
with him
in
on the phone
Atlanta.
more?
Meaning?
You said you spoke with him on the phone.
I have, yeah.
Did you speak with him on the phone every day? Did you speak with him on the phone once a week?
How long will it take the appellate court to make a decision on the judge? Asks Paige in the chat. I'm not sure. Now, this emergency appeal to the appellate court is about allowing Mr. Steele to not be put in jail and have a stay on that until the appeals court have taken up the case. There are at least 2 appeals sent to the appeals court, to my knowledge, and hopefully weeks. Hopefully, because this is such a rarity that the appeals court kind of needs to handle it as soon as possible. But I'm not sure. Hopefully within weeks.
Speak with him on the phone once a month.
I spoke to him when I spoke to him.
You said that you all would see each other. When you would see each other, what type of things would you all do?
Shoot dice. Go to parties. We mainly shot dice.
Did you ever speak with Quay via FaceTime or some other video chat?
What you mean, some type of other video chat?
Well, let me just ask first. Did you ever speak with Quay on FaceTime?
I can't recall if I have.
Would you give Quay advice?
Would I give Quay advice?
Yes.
What that for me?
Did you advise Quay on certain people he should hang around with
Oh,
or not hang around with?
what about it?
Have you advised Quay on individuals he should or should not hang around with?
I probably have.
Specifically, did you advise Quay on whether he should hang around?
That's the question.
Have you ever advised Quay on hanging around Young Thug?
I told Quay that, man, I have a personal problem with Young Thug.
Did you advise him on whether or not he should hang around Young Thug?
I thought I just answered it.
No, you told him that you answered you had a personal problem with Thug. That wasn't the
Right, and I
question.
told him that, yeah, I advised him that.
What is the that you're referring to?
Whatever you just asked me, I agreed to what you just said.
So for clarity for the record, you've advised Quay about hanging around Young Thug.
What's your objection? He hasn't really clarified. I think she's trying to get him to clarify it, so I'm over your objections.
You advised him on hanging around Young Thug.
I told Quay that he needed to watch who he hang around.
And was that in 2021?
I don't know when it was.
You met in 2021. Have you spoken with Quay in this year, 2024?
No. You said, have I talked to him this year?
Yes.
No.
What about last year in 2023?
I cut all communication with everybody, period. I haven't spoken with nobody.
We've talked about Quay, Thug, Shannon, and Ye. Do you know any of the other defendants?
No, I don't know nobody else. I don't. How many?
We've spoken about 4. Do you know any of the other defendants?
No, I don't know.
Do you know someone by the name of Trontavious Stevens or Tick?
Who?
Tick or Slug?
Yeah.
Do you know him by his given name or just Tick or Slug?
I know him by Tit.
Okay. About how long have you known Tick?
For a while.
How'd you meet Tick?
Don't know.
And when you say for a while, would that be more than 5 years ago?
Yes.
Back when you first met Tick, how would you describe your relationship with Tick?
I don't know. I can't reflect back on when I first met him.
Why can't you reflect on when you first met him?
I know a whole lot of people.
What was your relationship like with Tick?
What you mean?
Was it a good relationship, bad? Did y'all get along with each other? What was your relationship like with Tick?
Just like it would be with anybody else from that I know.
Do you get along with everybody that you know?
Yeah, we cool.
So are you saying that you were cool with Tick?
That's what I said.
What types of things would you do with Tick?
What you mean?
Did y'all go out? Did you go shoot dice? Did you go to the club?
Joey's first fan says, according to the lawyer from Mr. Steele, the appeals court should rule quickly on the bond. She said a day or two. Yeah. That in itself, I would assume, takes a bit, will be done faster since it's not, well, it should be faster. And Miss Merchant rarely exaggerates what she knows. So would assume that she is correct on that one. And then we have to wait for the actual appeals to run its course. Hopefully a few weeks. Hopefully.
Okay.
Hopefully I have to before the 25th. That is everybody's absolute hope, that Georgia Appeals Court tells this judge, you did what? An ex parte meeting with a sworn-in witness with the prosecution and not the defense attorneys? Send us the transcripts. They can actually force Judge Glanville to release those transcripts. They can even force everybody who was in that room to submit sworn affidavits under the penalty of perjury. That would be good. But we never know. We don't know until it happens.
Things young black men do in their neighborhood.
I don't know what young black men do in the neighborhood. So what is
Try to survive and stay away from the police.
do you do anything else besides trying to survive and stay away from the police?
Yeah, I know they asked the transcript to be part of the appeal, but I assume Judge Glanville will fight that tooth and nail.
Yeah, get locked up.
Okay. Anything else besides getting locked up?
You got my criminal history, right?
We're not talking about your criminal history, Mr. Copeland. Is there anything else that you all used to do?
I don't recall.
I'm going to show you permission to approach Marvin.
Could you show that to defense counsel?
And now they are looking at evidence again. I would assume it's more photos. Woohoo! Oh, I would be amazed if it actually was Miss Weaver. That Judge Glanville was betrayed by his own court reporter. No, I don't think so. I really don't. It's quite evident that it is Miss Butkiss. I don't remember her name. I don't remember. I'm bad at names. I'm bad at remembering names unless I repeat it constantly. Like Miss Hilton, it took a bit. a couple of months before I cared enough to learn her name. Miss Love? Yeah, because she has a funny name. Because she is all eight.
Tell me if you recognize the individual in 352 Yankee.
Yeah,
Who are the people at 352 Yankee?
me, Ted, and Liddy.
Your Honor, this house they would like the evidence, states 352 Yankee is happening.
Any objection to states 352 Yankee?
Yeah, I have an objection, Your Honor.
Basis.
It's misleading portions of the image in approach. I can show that to you, Your Honor.
Sure.
Thank you, Ghost. Attorney Kayla J. Bumpus. Thank you. Oh, look at that. They have yes, no curacao. Let's say it all together, folks. Sidebar counter 207. Oh. Oh. Did you see my 200 celebration? Oh, you need to see my 200 celebration. We actually had a live stream. Well, it was on live stream, so but let's show it. Let me find it. Hold on a second. That's my channel. No, not that one. Let's. Why can't I make this bigger?
All right, states 352 Yankees admit.
Oh, well. Here it is. I don't know why I can't make this any bigger. No. I have no clue. Sidebar counter 200. Woo! Oh. Ah. Sidebar counter 200. So, yeah. I mean, I have. This is what I need to keep you entertained, because at that time, a couple of days ago, it was after months of absolute boredom, which I'm trying.
All right, states 352 Yankees admitted over objection. Maybe published as you see fit.
Could we bring us the image? Mr. Copeland, you know who you are. If you can tell the jurors who is Tick and who is Little D. Mr. Copeland, who is Tick?
In the middle.
All right. And then Little D, the one with the Dallas Cowboys sweatshirt.
If this me, this Ted.
Okay.
They got no choice but to be Liddy.
Earlier, you talked about another Little D that you called your son. Is this the same Little D?
Do they look like the same little D?
I'm asking you a question, Mr. Copeland. Is it the same little D?
No,
How do you distinguish this little D from the other little D?
they look like two different people.
When you are addressing or talking about them, how do you distinguish the two little Ds from each other?
What you mean?
Do you call one of them little D from Cleveland?
If you ask me which little D I'm talking
And
about,
that's what I'm asking you. When you are
well, you
talking
should just
about,
ask me that.
Mr. Copeland, which little D, how do you describe him if you're talking about him? If you're talking about the two little Ds, how do you distinguish this little D?
I just said he looked D from Cleveland Avenue.
Okay, thank you so much. About how old were you all when you took this picture?
I don't know.
Do you have hair on your head when you take a picture?
What you
When you
trying?
took a picture?
It looked like I got hair on my head.
Okay. How long ago have you been bald?
When I got out of prison.
Okay, so this is before you went into prison.
This is an old picture.
And that's what I need to know. Thank you very much. How long have you known Little D from Cleveland?
Huh?
How long have you known Little D from Cleveland?
Know who?
How long have you known Little D from Cleveland?
I knew him back in I think I knew him in 2013.
Do you recall?
I think.
Oh, that's fine. Do you recall how you met?
Well, you just see somebody around.
Back in 2013, when y'all first met, how would you describe your relationship with him? Were
With
y'all
who?
friends? Cool?
With who?
Little D from Cleveland.
How would I describe our friendship?
If you had, let me ask you, did you have a friendship with Little D from Cleveland?
I wouldn't say a friendship.
Did you hang out with him, like go to the club with him, or you talked about shooting dice, concert? Did you do those things with Little D?
I try to get over on him.
What does that mean?
If he shoot dice with me, I'm trying to get over on him.
Okay. I guess then you would try to win the dice game?
I won't treat him like a friend.
You would not. Have you ever had Little D purchase guns for you?
Nope, but I took a gun from him.
So your testimony said that he did not purchase it for you, that you took a gun from him.
You talking about a specific situation?
Has there ever been a time that you had Little D purchase a gun for you?
My federal case?
Is there a time that you,
I said my federal case.
and when you say your federal case, what do you mean?
The case they sent me to the feds.
What are you talking about for the jury?
I'm answering your question.
I understand. You're saying your federal case that they send you to the feds. What does that have to do with Little D purchasing a gun for you?
The homicide investigator told me that I had the rights to protect myself.
Okay.
So I believed the way he said and got a gun to protect myself.
And how did you get that gun?
I paid someone to go, I paid Lil D to go get it.
Thank you. And was that in 2015?
Yeah.
Do you know someone by the name of Antonio Sledge? Do you know someone by the name of Antonio Sledge?
No.
Do you know someone who goes by the name of Munson?
Yes.
How long have you known Munson?
I don't know what year I met him.
Was that before you met Little D from Cleveland, after Little D from Cleveland? Or
Maybe- I think it's before.
Sitting here today, do you remember how you met him?
So Monton?
Yeah,
Yeah.
I do met Munson.
I about to do something to him.
What were you about to do to him?
Beat him up.
Why were you about to beat him up?
Because he was in the wrong business.
After you were about to beat him up, did you somehow develop a friendship with Monson?
Somebody else called me to protect him.
Okay. When did you get a call in order to have to protect Monson? If you're talking about you met him before 2013 and you're about to beat him up, when did you get a call to have to protect him?
That same day.
And if you were about to beat him up, let me strike that. Did you make a decision to protect him? Did you decide to protect him?
Me?
Yes.
What you mean?
I asked you, how did you all become friends? You said someone.
He called my phone, talking crazy.
Let me ask just a simplified question. At some point, did you and Monson become friends? Yes or no?
Later down the line.
Okay. When did you all become friends?
Later down the line.
Was it a month after you were about to beat him up? Was it 2 months after you were about to beat him up? Was it a year after you were about to beat him up?
It was within the time frame where he caught my phone.
I guess I'm
A couple days, I don't know.
Let me ask you this. In January of 2015, at that point in time, were the two of you friends or
Yes.
privately? I'm going to speak about a specific time frame. End of 2014, early January 2015. How often would you and Monson spend time together?
Can you say that again?
Sure. I'm focusing on late 2014,
Late 2014.
January of 2015.
All right.
How often would you and Monson spend time together?
Every day.
Every day.
Well, I'm saying a lot.
And during that time frame, when you all would spend time together, what type of things would you all be doing? Again, late 2014, January 2015.
You said what was we
What type
doing?
of things would y'all do?
Gamble? Like we gamble most of our time. Shoot dice.
Anything else?
Go out. That's it.
Is it fair to say, would you all talk to each other on the phone as well?
No. The first we talk on the phone is what you got going for today. What you get? That's it.
And have you ever FaceTime with Monson back? I'm talking about late 2014, January 2015.
I don't, not that I know of.
Permission to approach?
As long as you show them the documents to defense counsel.
Yeah, and showing the entirety of Woody's testimony will be like that until they have enough foundation to ask him, did you commit crimes in furtherance of these guys? Did you witness any crimes by these guys? So we will be watching this probably for the rest of the week, which tells me, and this is why I go
can't see
to
this photo.
lunch and not the afternoon today, because so I can condense this to something interesting. Oh, thank you, Aaron. Let's see here. Are you serve? Then thank you so much. I already thanked you. If you're not, it haven't shown up yet. But thank you so much, Aaron. Thank you so much. Hello, reform convict. He a real killer, and yet he has immunity. Yeah. He admitted or confessed in that secret ex parte meeting, allegedly. He was the actual person doing the drive-by shooting of Donovan Thomas. And if the judge, if that is in the transcript, and the judge sends it to the appeals court, and it's actually in there, or say Miss what's her name now again? What's her name? You said it earlier. I keep forgetting her name. Now, Woody's former lawyer. You said it earlier, didn't you? Well, if she submits an affidavit to the appeals court, yep, this was said. I don't know what's not in the transcript. Oh, that would be
And looking at
interesting.
what's on the screen, that appear to be the same image.
Yeah,
All right.
man, won't talk.
That's your own song. Thank you. Your Honor, this how to stay where I can send the states to the 353. Thank you.
Bumper.
Any
Bumper.
objection?
Thank
Any
you.
objection to state 353 Yankee? All right, hearing none, it's admitted and will be published as you see fit.
We don't know how he said it, or why he said it, or if he said it. This is still an allegation, but the evidence we have for that is the reaction from the judge. That Mr. Steele was not supposed to have that information. And Judge Glanville said enough in the back and forth between him and Mr. Steele that leads me to believe that what Mr. Steele said was correct. Now, it could be, I'm said as, I might have, well, what if I confess to it on the stand? He might have said that. Or, I did it. Psych. We don't know. We actually don't know until we have transcript and sworn affidavits from the participants. Oh, look, another picture.
And Mr. Cole, is that moved with the-
I don't understand why this is admitted, because this is prejudicial. This has, I mean, two people flipping the bird to the camera is when they have literally hundreds of pictures. Why admit this one, who definitely is prejudicial?
I'm asking.
There's man won't talk.
Do you know someone by the name of Quentin Porter?
Who?
Quentin Porter.
No.
Know someone by the name of Big Blue?
Who?
Big Blue.
Yeah.
I'm gonna show you what's already been admitted at 651 W. Who is at 51 W?
Big Boo.
Yes. Who's the, you know another person?
Shannon.
And is Big Blue still alive?
You say, is he still alive?
Did he pass away?
No, he was killed.
Okay. When did you first meet Big Blue?
I don't know.
Was it around at 2013? I mean, excuse me, before 2013?
Yeah, that would be amazing if you asked that question.
I knew
You
of
know
him
what
before
that
I knew
answer
him.
means?
So
Yeah,
I can't recall when we
or
actually.
you.
Let me ask you this. Did you know Big Blue before you knew Little D from Cleveland?
Yes.
Do you remember how you met him?
Who?
Big Blue.
I said I knew of him before I. So
I'm talking about when you actually started meeting him, do you remember how you met him? How would you describe your relationship with him?
what you mean?
Like when you first met him, was he like a big brother, mentor, friend? How would you describe your relationship with him?
I used to see him with a lot of money. I admired it.
And would you speak with him often?
No,
Did you see him often?
I saw him a lot, but we didn't communicate a lot.
Earlier, there was a picture with an individual by the name of OG Bentley. Do you remember looking at that picture yesterday?
No, I don't.
Hey, Fiery Red, I saw your update. I can't give more than hopes and prayers for you, my man. Hopes and prayers for you.
You remember seeing that picture yesterday?
Yeah, I remember.
Okay, and the individual that's to my left, I think yesterday you said his name was OG, or you knew him as OG?
You talking about this dude right here?
Yes.
What about him?
Do you know him?
Not personally.
When you say not personally, what do you mean? Have you ever spoken with him?
Not personally is a perfectly valid answer.
I'm pretty sure I probably have.
Have you ever gone out with him to the club?
Yeah.
Back in 2014 and January 2015, have you ever spoken with him during that time period?
Him?
Yes, sir.
I don't even pay this guy no attention, so I barely remember him like that. Like he never been a factor to me. I don't.
When you said that you've been to the club, is that around 2014, 2015, or some other time?
You said something about the club.
I asked you, have you gone to the club with him? You said yes.
Oh no, I'm saying like to be honest, I thought he was his manager or something. I'm not a person that asks questions. So I didn't know, I didn't pay him no attention. Like we didn't have any comment or nothing. Like I see no reason for me to talk to him.
If when appellate court takes this up, will that proceeding be streamed? It might be. But I will give you the most boring, vague lawyer answer. It depends. News organizations probably will submit that they want to cover that. Will it happen? It depends on the appeals court in Georgia. I hope so. I would stream the ever-living fork out of it. I've been covering this case for over a year. Hell yeah, I'm going to cover it if it's streamed.
What made you think that Bentley was Thug's manager?
You said what made me think that?
Yes.
From my observation, that's what it looked like.
All right. Do you know someone by the name of Alexis Greer?
No.
What about someone by the name of Max?
Yeah.
Okay. How do you know Max?
What you mean? How I know her?
How do you know Max?
She his sister.
Who's the he sister that you're referencing?
Young Thug's sister.
Right. Does she go by any other name besides Max?
Dolly.
How long have you known? Strike that. What do you call her?
Both.
Okay. How long have you known Dolly?
I don't know. I don't know how long. I haven't known her long.
I believe yesterday you testified that you met Mr. Williams or Thug in 2014. Did you meet her around the same time that you met Thug?
I don't know which one of them I met first, but I didn't know they was related until later.
Do you remember sitting here now how you met Dolly?
Say it again.
Do you remember sitting here today how you met Dolly?
I remember I was playing with her.
When you say playing with her, what do you mean?
Like playing, talking, playing, joking, laughing, haha.
Was this in the studio, in the house, or somewhere else?
It was outside.
Have you ever considered her a friend of yours?
Yes.
How would you describe her friend? How would you describe your friendship with her?
How would I? What you mean?
Was it a good friendship?
She was cool. Like
That is, everybody give your hopes and prayers to Fiery Red, who is fighting for his life. He will have a transplant evaluation next month. Keep fighting. Keep fighting, Fiery Red. Keep fighting. And yes, I know your membership was gifted. I saw it when it happened.
I know you just talked about being outside and y'all were laughing and playing. Have you ever been to the club with her?
club as we going out the club or as her brother going to perform. I recall going to shows with her as her brother go perform, but I can't recall if we've been out in the club together.
Did you ever speak with Max over the phone?
I don't recall. You met on FaceTime?
FaceTime or just regular phone?
Just her call?
Yeah.
Yeah, I don't recall talking to her.
I'm going to show you what's already been admitted at 6 Charlie.
There seemed to be something going on after the morning break. I'm bored out of my skull. Okay, there's another picture and another picture. They're looking at pictures. And all right, I have to do this. Sidebar counter 208. Oh. All right, and then they are on a break, and then they come back from the break. Let's see here. All right. Let's see what's going on. Did I see the movie The Northland? Yes, I did. It's a really good movie.
I know that the state is running on attempting to engage a video before we grow.
Northman.
The defense is going to have some objections to that video, so I didn't know if you wanted to take that up before Mr. Copeland comes in.
How long is the video?
There's gonna be 2 videos, Your Honor, and they're only each one is 17 seconds and one might be like 10 seconds.
All right.
Okay, there's an
Can you
objection
identify them
towards
for the record, sir?
a video of sorts.
347 Yankee.
And they will hold a short hearing about it where the defense is objecting to it. Probably this is just for the record because Judge Glanville will listen to the defense, he will listen to the prosecution, and then he will talk for the prosecution. That is what he does. And he has done that the entire trial. I've been shouting this from the rooftops for months about Judge Glanville's bias.
Yeah, this is my attire for the day. You know, this is how I'm swagging on a bitch and a boyfriend. You can get it. Got my youngin' with me. You deal what I'm saying? Just the motherfucking booties how we do it, nigga. Dollar White Production. Hi. Yeah.
No attorney locked up in the back room somewhere in this trial. He is at the table. His sentence starts on Friday at 7 p.m. unless the bond motion to the appeals court goes through the next couple of days.
Was that it?
Yes, Your Honor. That's the first one.
That's 347 Yankee? All right, let me take it by the numbers then. Mr. Sharp, what's your objection?
I'm going to defer to Mr. Steele on that particular video.
All right, Mr. Steele, do you have an objection, sir?
Yeah,
What's the basis, sir?
I would ask for the basis of the reason that's being sought to be admitted under what ground, because I'm going to object to cumulative if it's association. I'm going to object to relevance because I don't know what the relevance of saying this is the attire for the day. And then there's commentary under the right of 347Y, it's written words, which I would object to as well.
On what basis for the words?
It's a social media posting on a person's account, which this court pronounced Scarfax, and it's not Jeffrey Williams' account. He didn't write those words. They're unknown people on some of them. Scarfax, as this court pronounced it, is Demekian Garlington.
So is it, what's the basis for your, for the third base for your objection? Okay,
For the,
for the writing.
And then for the rest of it,
I heard relevance,
yeah,
cumulative, and hearsay. Is that it?
I would hope so.
Okay.
And then, of course, the reason I say cumulative, there's been detectives with an S who said who are allegedly in association here on the indictment. There's been other witnesses identifying people who are part of the indictment that allegedly are part of a crime conspiracy. There is, this witness has already said who he associates with and identified a series of pictures, but there's other numerous, I don't know the number. There's numerous pictures showing associations. I just don't know when there's enough. I've objected to cumulative. I know you gave me a continuing objection, but at some point, it just seems like a waste of time in the forum.
All right, thank you, sir. All right, state wish to respond. Three bases, relevance, cumulative, and hearsay.
Yes, Your Honor. As to the hearsay, Your Honor, the state has no objection.
It should be hearsay because it's not Jeffrey Williams' account. And it should also foundational because there's no way of knowing if anything in that has been doctored because it's not an original. Here's the thing, the judge doesn't care. He really does not care. He have allowed in numerous of these videos which are reposts, and at one time he allowed in a video that was clearly a composite of two different videos that was posted by somebody else than the people in the videos, and he still allowed it in. Yeah, exactly. A Welsh lady reads, no authentication.
Moving the information on the side and previously.
All right, well, that's done. That's one basis. I'll sustain that that part of the objection. Okay, so what about the other two, relevance and cumulative?
As for relevance, Your Honor, again, this is direct evidence of the nature of the relationship with several individuals on this indictment. Inside of this video is Mr. Williams.
Mr. Williams, Mr. Copeland, Mr. Arnold
They showed
are
numerous
in this
pictures
video,
now for a
and it
few
shows
days.
their association together. We have pictures, but this is them. Oh, and Dolly White, who's going to be, who we've heard about as far as the Little Wayne bus shooting, and we should hear more about Ms. White as the rest of this particular act develops, Your Honor. It shows the relationship of these parties together. The defense has been that
you have been doing this for months with pictures and videos. As Mr. Steele says, when is it not cumulative? When is it not cumulative? This is the prosecution's case, and you've told everybody to speed it up because of the jurors. Remember that, Judge Glanville? No, he doesn't care.
Mr. Copeland is not really a friend of Mr. Williams. He is a friend of, I believe from opening statement, a friend of Demekian Garlington. And again, this shows that that's a contradiction to that this is Mr. Williams in his home, it appears, or someone's home, let me say that. And it shows the nature of their relationship. And so we think that it's relevant. It's not cumulative, Your Honor, because this is not new. This is not the same evidence as the pictures. This is different evidence. One, it's a video. And two, that this would be analogous that we have evidence of a murder. We can bring in different pieces of evidence. And this is a different piece of evidence. It's video evidence showing the nature of their relationship.
All right, ma'am. Anybody else have an objection? Okay, I'm going to admit states 347 Yankee over objection, Mr. Steele. Mr.
Judge Glanville
Steele,
does not
I'll
care.
I'll just make it
whatsoever.
And we're still continuing, and I hope, as under the belief, for cumulative for all association.
No, I'm not giving you. I mean, I'm overruling the objection. I've sustained it as to hearsay, but I'm going to admit relevant. It's relevant, and I'm not going to. It's not cumulative at this point. So, okay.
But if it's hearsay, they don't need to apply the other things. This is so stupid. This is not a three-part objection where they have to win all three. If one of them, the hearsay, then it doesn't come in. But I've been telling you guys for months now that this judge does not care. And at this point, he has nothing to lose. He just don't want defense to get to cross-examination before before the appeal. I mean, he will probably allow everything in until before the appeals court, so they can't ask him questions to the jury in open court, just in case.
All right, can I see 343 Yankee, please?
Yeah. Everybody and their associates are now streaming about what I've been saying for months, that this judge is not fit for his position whatsoever. I only wish I could get a little bit more recognition for all the world. I know it's me just whining a bit here. I'm not the whining type of guy. I just wish that, because most of this information I've been talking about for months.
Fuck you, pussy. All right. Yeah, we got turbulent out here.
Aaron Wallace asks, what is that? Have any part implicating a murder? This is a part of the RICO Act, and the murder of Donovan Thomas. They still have to prove that all these guys are associates in a criminal enterprise, the YSL gang. Because if they don't, the jury can't convict them on the RICO charge. But here's the thing. This has been going on for 7 months, and showing pictures of people together has been at least 50% of the evidence. Videos, everything. It's so stupid. Yeah, Welsh lady reads, I know. Some of you has been watching since day one and screaming with me. And I appreciate you so much. No Cursan says you are like a reverse Don Quixote. People have seen windmills and dismissed it, where you have seen the actual man turning the wheels in the windmill costume. Yeah? Thank you.
Okay, Mr. Sharp, do you have an objection for 343 Yankee?
I do.
All right, and the basis of that, okay, the bases of that objection, sir?
Okay, can I just describe what I see first? Because I think it's important that we just talk about what we're seeing. I believe that to be Mr. Kendrick in the foreground right now, Mr. Copeland in the background. Mr. Copeland says F-U-P-U-S-S-Y, and it's something that I can't decipher afterwards. Then the camera pans to another gentleman who I believe may be Martinez Arnold. He says to my ears, we have a target on our heads. And then, and he also uses what I believe to be drugs. And then it goes to other individuals. I believe I saw Quindarius Zachary present as well. So I have several objections. First of all, what Mr. Arnold, or the person I believe to be Mr. Arnold, says is hearsay, and it violates the confrontation clause. He is not on the witness stand. I do not anticipate him taking the witness stand. Him saying we have a target on our heads is a statement that violates both the confrontation clause and the hearsay rules. It's clearly not any sort of co-conspirator statement. Also, regarding the video and audio as a whole, I guess the state would argue that it's relevant to show association. I think that's already been established. I think that's cumulative. I think the probative value of that at this point, and the marginal probative value after all the other evidence to show association is minimal. Compare that with the prejudicial effect, which is these gentlemen being around and engaging in drug use, the profanity,
the different things of that nature, I think that the prejudicial effect and the unfair prejudice substantially outweighs any probative value from this video. However, Your Honor, if Your Honor were to find that it's relevant to show association, which I would argue is the only possible relevance, then my concerns could easily be alleviated by admitting the video and not the audio, and therefore it would cure the hearsay and confrontation clause concerns from the audio and what is said by a non-testifying declarant.
All right, thank you, sir. Okay, State.
So first, Your Honor, as to the confrontation clause, Your Honor, this is not a testimonial statement and made to law enforcement. So this would not be a confrontation clause issue, Your Honor. As noted, this is a statement by a party opponent.
How's Mr. Arnold a party opponent? Just tell me.
Because he's on the indictment, Your Honor. He is a previous co-defendant in this case. Although he's pled, he's still a party opponent.
So you're saying his statements are admission by a party opponent?
Yes, his statement being admission by a party opponent.
Okay.
As far as what Mr. Copeland says, F-U, P-U-S-S-Y, Your Honor, the probative value or prejudicial nature of that cursing, we've omitted songs at this point that have.
If it's not for the truth of the matter, then it's not relevant. But we already know that this judge
Cursing in it, so I don't know how
don't care.
prejudicial that particular line would be. Mr. Copeland is the current witness on the stand, so they want to cross him on his use of language. They can do that, but don't believe that in and of itself should keep this video out. As it relates to the smoking of the cigarette, we don't know what that is. It looks like a cigar, so it would be speculative to believe that it's drugs or anything else, because we don't know. I didn't see in that video a bag of marijuana sitting around anywhere, so we don't know what it is. So it'd be speculative to determine if that is any type of drugs or illegal substance, Your Honor. Also, this could be an adoptive admission as Mr. Kendrick.
I mean, there are people in that video who are not in this, not even indicted, not even mentioned. And that, I mean, if the confrontation clause is not met, it's not coming, shouldn't be coming in. And cumulative, we've been watching this pile of shit for months.
If it is what Mr. Arnold says, that we have a target on our backs, at no point in time did Mr. Kendrick, who is the holder of the video, deny that statement at all. An adoptive admission is admission by silence. An admission by silence may be created against the party who remains silent in the face, and this is of an accusation.
This is one of the, I mean, there are a lot of stupid rules and exceptions. An admission by silence must be in contract law. Yeah, I do a bit of that because labor law. There's no such thing as admission by silence. It has to be an active admission from everybody involved. If it's not valid. They should apply that here. Dave can come on if he wants to. He knows how to get here. He has access to my StreamYard. But I also know that Dave is in the middle of a trial himself. Yeah. Dave is an active criminal defense attorney, and he's in court. He's probably having lunch now and writing to us. Thank you, Dave.
Such admissions are proved up when the opponent establishes the following elements. At a prior time, someone made an accusation. We believe that we have a target on our back is an accusation. Then Mr. Kendrick's failure to say anything to it would be an adoptive admission to that statement. But again, we have a target on our back. It's something that a party opponent states, and that would be relevant. This video was taken in 2014, which is in and around the time of the beef that we believe the beef may have started between If Gang and YSL. And so that would be relevant information for the jurors to hear as well.
Anybody else have an objection before Mr. Sharp? Before I let you respond again? Mr. Sharp, just wait a second. Mr. Weinstein.
Good luck to you, Dave.
I just wanted to make one statement regarding Mr. Kendrick allegedly holding the camera that entire time. If you watch the video, you can see that there is a jump cut in this video.
What is it?
Jump cut. There's a part where there's an incongruity in the video, and it's prior to the person who allegedly says there's a price on our head. If you watch it again, you can see. So the fact.
Are you saying it's spliced or it's too,
Or
is that a
it's
jump,
not-
is that what a jump cut is, or?
It stopped and started again or something. You can watch it when you see it. I'm not saying the state spliced it. I'm just saying it looks at one point like the video stopped and then started again. So while it looks like Mr. Kendrick is doing a selfie video here, when you watch it play all the way through, and it's only 17 seconds, so you can see it. When you watch it play all the way through, before it goes to the individual that makes the statement about the price on the head, it's not at all in evidence that Mr. Kendrick is holding the camera then.
All right.
Your Honor,
So what's your specific objection? That
My
that
objection is
being
to the
that,
allegation that Mr. Kendrick has adopted that statement because he's holding the camera
Okay.
and did not disavow it.
all right,
That's
sir.
my objection.
All right, sir, thank you. All right, Mr. Steele and then Mr. Shard again.
Your Honor, there's not a case I can find that a person in Mr. Arnold's position would be a party opponent who is indicted. He has cut a agreement that this court sentenced him under, and he is no longer a party here. So,
He's still on the indictment though, right?
yeah, so I can't find any case that says the fact that a human being, an indictment.
Yeah, just because it's mentioned in the indictment, if he has cut the deal, he is released from. Jesus Christ, Judge.
Is hearsay. It is the district attorney's allegations. It is total rank hearsay under Brown versus State, which we discussed earlier.
Yes, sir.
So I disagree strongly, and I just can't find it. If someone has it and I'm wrong, I want to learn, but I can't find anything that supports what the state says. That this is a statement of a party opponent.
All right, sir.
I couldn't find it either with Mr. Winfrey. If you remember him, he did not resolve his case, but he is on the indictment. I still can't. He's not here, the party. And then generally we get a 105 instruction, 24-1-105 instruction.
You may still get one at some point in time, but not now. Okay? All right, is there anything else?
Not on that issue.
Okay, all right. Mr. Shard?
I mean, I agree with Mr. Steele, but with Winfrey, but this is one step further because he's not a party opponent. Yes, it's a little absurd to say he's a party opponent to the state right now. He signed a plea deal with the state to testify. He signed declarations written by the state. He's not a party opponent, but more importantly, while he is on the indictment is no longer pending against him. He has resolved the case.
But I don't think that makes a difference as to whether or not, I mean, you can still be on the indictment, you can resolve your case and conversation still could be, theoretically admissible as to others. So, but I'll hear from the state, but that's not my understanding, Mr. Shard.
Football game, the time runs out in the fourth quarter. The other team's no longer your opponent. He does not have a pending case. There's nothing going on.
While that may be true.
And there's no.
While that may be true, but I still think the statement can be used for other purposes.
Can I just respond to the adoptive admission? We have a target on our heads is not an accusation. Okay, that's not something that would clearly elicit the response of Mr. Kendrick to say, oh, well, hold on, you're saying something about me, so let me clear that up. That's what adoptive admissions are. You say something about me, and then I have to clear it up, or it's assumed that I agree with it. That's not even close to what adoptive admissions are.
All right, thank you. State anything else?
One additional, Your Honor, this also
be considered a co-conspirator statement as a part of the larger conspiracy of the gang of YSL. Again, this is in November of 2014, where we believe the beef between YSL and the If gang is beginning to arise and heat up. And so the fact that he says we have a target on our back. So
yes, Gwendolyn.
we will argue is
in his
YSL
mind,
and the hour is the YSL.
He is not only the interpreter of law in this courtroom, he is the interpreter of all law in all of the land. And he doesn't need to use statutes or case law or anything. His word alone. And sadly, I must say, until a higher court says otherwise, he can do it. That is the sadness. When you have a judge completely void of ethics and morals and with a grandiose image of himself, this is what happens. He's a judge, jury, and executioner. He would throw out the jury if he could. He would sentence them on the spot if he could.
And therefore, this statement could come in to show the larger conspiracy, which would be the gang conspiracy as well.
And to be a statement a co-conspirator statement, it would have to be in furtherance of the conspiracy. There's nothing about that statement that would indicate at all that that is furthering any
But
conspiracy.
that's a jury question.
Well, no, it's not.
That's,
Judge.
that, well, remember what I told you earlier, during the trial of this proceeding. At this point in time, there is evidence that's been presented by the state to show that there potentially may be a conspiracy. So as a result, that's kind of the entry. So I believe at this point in time that may fall into the category of whether or not a conspiracy has been shown. Now, whether or not the jury believes that, buys it, they've proven it, proven it beyond a reasonable doubt to a jury satisfaction will be determined later. And whether or not that particular statement was made in furtherance of the conspiracy is again
Respectfully,
a
Your Honor,
question.
I gotta disagree because there's multiple steps.
Yeah, I understand that, but
It has to be in furtherance of the conspiracy, and you as the gatekeeper judge
well,
make that determination.
I've determined I've determined that that's made in pursuant from what the state's telling me they're trying to get admitted to is made in furtherance of the conspiracy.
Yeah.
So
Okay,
yes.
well, may we have a continue?
This is the judge giving the prosecution a carte blanche. As long as they say in furtherance of the conspiracy, they get anything in. They would get a half-eaten bologna sandwich in just by claiming this is in furtherance of the conspiracy and it's a jury question.
Yes, sir, you certainly may, sir. Absolutely. Absolutely. All parties, the Harvey rules in effect. I'll make it a continuing objection. All right, anything else?
I do. Your Honor, I don't know how state could argue anything from those words. There's no context.
They've made an argument. You disagree. And I'm gonna rule in their favor. And again, the jury ultimately will decide that issue. But as a threshold issue, I've made that determination over your objection and over your, I would say, disagreement.
What I'm trying to ask the court to put into the framework of your ruling for the state is that the words we've been talking about does not go to potentially anything based upon that 17-second video or 10-second video. It is so out of context. We don't know what they're talking about.
But it's part of the state's evidence in this case. Ms. Hilton, you want to respond to that?
You're right. And so it shows a show of force. Like they collectively are bragging about whatever target that they have on their back and has put this on social media because this is posted on Mr. I believe this will be identified as Mr. Garlington's page. And so on their public social media page, because this is how we received it, they're showing that or telling to the world as a show of force, we got a target on our backs, whether they care or not. Again, that's showing that this gang, we got a target on our back, and this evidence can be placed before the jurors, and the jurors can decide what, if anything, they want to do with this evidence.
All right, I'm going to admit.
It's Rebecca Starr for $10. It's not Miss Butkiss. She's with the state, which is why Woody fired her. Woody's on YSL's side. He is making all this happen. And I live in Atlanta. People know Woody ended DT before trial. He got info to steal. Thank you so much for your information. Thank you for your super chat. And thank you. Hold on. Thank you so much. It's Rebecca. It's not on repeat. Jeez. I need to get a soundboard and I need to learn how to work a soundboard. Or I've seen content creators do interesting things where they just bring it up and I have no clue how to do that. And as that's good too. As Becca Lynn says, every time she left the podium yesterday, she walked over to the prosecution table and whispered with them. Yeah, I agree. And thank you again for your support of this channel. It's Rebecca the Star.
That's what.
Stop it with the world of doom.
Defense brought up, that's what Mr. Shard said that it said, so we quoted it from what Mr. Shard said. So I assume they all talked about it together before they came in here.
And if it's misleading, that's another reason to keep it out. If it's misleading, I'm saying what I heard. If Mr. Weinstein heard something different, then that's what he heard.
Fuck you, pussy. All right, yeah, we got turbulent out here.
Yeah, that I could see it. That is the. Let's look at that video in shorter.
Fuck you, pussy. All right,
There. Right there. That's a clear cut in the video. That's a clear cut. You cannot say it's still the same person holding the camera after that.
Yeah, we got turbulent out
Yeah,
here.
right. And again, I see 2 splices.
Fuck you, pussy. All right, yeah, we got turbulent out here.
Since we got turbans on our head.
That's fine too. I mean,
We got
the we-
turbans.
So that's the
We got turbans on our
we
head.
got turbans on our head. So
Okay.
the we is the we.
All right, okay. All right.
Is that?
Well, I'm gonna admit it and let the
Of course you are.
jury consider for what it's worth. All right, so I'm gonna admit 343 over objection. All right, anything else as it pertains to these 2 videos?
Yeah, and here's the thing, folks. The defense, they already know they are fighting a lost cause against this judge, but they have to do it to keep it on the record for the appeals. They have to do it, and they will keep doing it.
All right, bring Mr. Copeland back in, please.
Yeah, and it's mind-boggling that the first video he admitted, even though he sustained the objection for hearsay.
I'm sorry. That's this line. I take it.
Yeah, we don't have much left until they go on lunch. But what they do is they have a sidebar. Which brings us to sidebar counter 209. Oh. And with that, my dear folks, they are off to lunch. And I will watch the afternoon to see if it has anything of value. If it does, we will see each other back here tomorrow morning, Eastern Standard Time, where I will do the recap of the interesting part, and then we will move on to the live. So you get the condensed version with all the BS cut out. So let's see here, that one. Yeah. So we have reached the end of today's stream. Thank you everybody for showing up. Thank you for the super chats, the memberships, the PayPals. You allowing me to do this. You are the people who keeps me going. Thank you so much. From the bottom of my heart, thank you so much. I will send over you to Jeff at Legal Vices, who is covering the Karen Reed case. Tell him I said hi. Tell him it's a Viking raid. Okay? Again, thank you so much for allowing me to do this, and hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. See you tomorrow. Bye-bye.
In the court now where time stood still, generations pass on the hill. Prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight. Came in to visit her tonight. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption's grip tight as a vice. In this endless trial we pay the price.